Morning, all.
Good morning, Mr. Hearing Examiner.
Morning.
Morning, Mr. Williger. Good morning to all the parties, and Ms. Gonzalez and Chief Hearing Examiner Schanauer. This is our second day of hearings on the joint show cause motion in the San Juan abandonment and securitization proceeding. Before we begin with the examination of the Attorney General's witness, is there anything to address? Anything pressing that parties would like to address or of concern?
Hearing Examiner, this is Sabrina Twilliger. Just after we finish with Ms. Crane, but before Mr. Terry gets on, I'll just need a moment because we'll switch attorneys. I'll log off and Mr. Alvidrez will log on. Just wanted to alert you that that would be happening.
Okay, and I'll give you a little bit more time for that because I'll have my ruling on the ruling's prepared, but we have Ms. Crane already to testify, and I don't want to hold her up with listening to a ruling on an evidentiary issue that doesn't involve her. So I will issue that ruling on Nmprc's motion in limine regarding certain rebuttal testimony after the break. So unless there's anything else, Mr. Elliott, would the Attorney General please call its witness?
Good morning. Attorney General calls Andrea Crane.
Good morning. Can you hear me okay?
Yes, ma'am. Good morning, Ms. Crane.
Great. Thank you. Morning.
Ms. Crane, do you have in front of you?
Mr. Elliott?
Oh, I'm sorry. Yes, sorry.
Ms. Gonzalez?
Yes. Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Ms. Crane, do you have in front of you what's been marked OAG Exhibit SC1?
Yes.
Can you tell me what that is?
That's my direct testimony in this case filed on May 11th, 2022.
Okay. And this testimony was prepared by you or under your direction?
Yes, I prepared it.
And do you also have what is marked Exhibit SC1A?
Yes.
And can you please identify that?
Yes, these are 3 pages from my testimony with 3 corrections.
Okay. And those are all the corrections you have, right?
Yes.
Okay. At this time, I'd like to move into evidence OAG 1, SC1, and 1A.
We haven't had a chance, Mr. Elliott, to look at the corrections.
Okay.
And this wasn't filed ahead of time, was it? The notice of errata or the errata?
The errata was filed on
Oh,
the 21st, sir.
okay, it was. Thank you, sir.
Yes.
Okay, but we still have to review. Okay, are there any objections to Ms. Crane's testimony being admitted?
No objections.
Okay. Hearing no objections, what's labeled OAG exhibit, is it labeled OAG exhibit 1, Mr. Elliott, and not SC-1? Or am I misreading it?
I believe
It's
I
mislabeled. What I just downloaded from the Dropbox folder for the OAG, which stands for Office of Attorney General, says OAG Exhibit 1. So subject to, am I wrong? You're muted, sir. Can you unmute yourself?
I'm sorry, I'm looking at the Dropbox right now, and I see it listed as OAG Exhibit SC1, comma, direct testimony of Andrea Crane.
Open the document. That document is what the court reporter, Ms. Gonzalez, is going to download. She's not going to download the Dropbox
Okay.
folder listing of documents.
Okay.
So
I apologize.
subject, and again, not to be a stickler, but we've had a prior proceeding, and Ms. Crane testified in that proceeding, and her testimony in that case was probably labeled Attorney General Exhibit 1 as well. So that would be duplicative. And so in order to distinguish it, we need it labeled as we discussed at the pre-hearing conference and set forth in the pre-hearing order. We need it labeled OAG Exhibit SC-1. And subject to that correction and uploading of the correct exhibit with the correct labeling, OAG Exhibit 1 is admitted.
I pass the witness.
Thank you, sir. Pnm, Ms. Terwilliger.
Pnm has no questions for Ms. Crane.
Okay, let's see. For Ms. Crane, CCAE Prosperity Works had reserved 5 minutes of non-friendly cross-examination.
Sir, at this time, CCAE and Prosperity Works do not have any questions for Ms. Crane.
The same for the next up, Mr. Mark, Sierra Club, 10 minutes of non-friendly cross-examination.
Thank you. I don't have 10 minutes, but I do have a question.
Okay.
For Ms. Crane.
Good morning, Mr. Marks.
Can you go to page 16 of your testimony and the Q&A that begins at line 11?
Yes.
Okay. You conclude that question by saying the specific mechanism is less important than the commission's ruling. I would like to direct you, though, to the first part of this Q&A and ask you, assuming that the commission agrees with the Attorney General and other parties that Pnm's current course of action it is contrary to the financing order and so forth, could you please address the trade-offs between the two remedies that have been put forward, either accumulation of regulatory liability or the commission, whether the commission would order the company to issue the bonds immediately and institute a credit? Could you address those?
Objection, hearing examiner.
Overruled. The hearing examiner might ask such a question. Anyway, so we'll just allow it. Go ahead.
Okay, sure. My principal concern is, as I state, is that ratepayers become whole. A rate credit does have the advantage of returning funds immediately, obviously, to ratepayers. The one concern that the commission may have about a rate credit is that it may lead to rate volatility, that being a large refund now and potentially then a large rate increase in it, let's call it a year or 18 months from now when there's another rate case. For that reason, the commission might be more comfortable with the regulatory liability. The commission could certainly order that a regulatory liability be established with carrying costs at the company's weighted average cost of capital. That would, that's very common that there be a requirement to accrue carrying costs while the regulatory liability is on the company's on a company's books. That would keep ratepayers whole and protect them against any loss of benefits due to the time value of money. So as long as there were carrying charges on that regulatory liability, ratepayers would be whole. And then the commission in its next base rate case, in the company's next base rate case, can look at the size of that regulatory liability. They can look at the size of the rate increase that's being requested by PNM, and they can determine what they think is an appropriate amortization period to return that regulatory liability to ratepayers, given those other variables. And so I think the regulatory liability might have some advantages over just ordering a rate credit, but obviously that would be for the hearing examiners and the commission to decide.
That was it. Thank you.
Thank you, Mr. Marks.
Thank you.
Mr. Albright,
Thank you, Mr. Hearing Examiner.
I had you down for 10 minutes.
Yes, I'm not sure I'll need all that, but I do have a few questions for Ms. Crane. Good morning, Ms. Crane. I'm Jeff Albright with J. Albright Law LLC, representing Bernalillo County.
Good morning.
I just have a few questions mostly for clarification. So could you turn to page 9, please, of your testimony?
Yes.
On page 9, where you talk about once through base rates and again through securitized bonds, beginning on line 14 through 17. Could you explain the timing that you see with regard to the securitization? Do you see that as a single securitization, or do you see that as multiple securitization, as depending upon when the units are actually abandoned?
Do you mean because they might not be abandoned at the same time?
Correct.
Okay. I actually hadn't made that distinction. I really didn't consider the possibility of two different timings for the securitization. You know, I think the policy would apply either way, whether there's one securitization or two securitizations. The result should be the same, that ratepayers are made whole for any amounts collected in base rates relating to San Juan after abandonment.
Do you think it has been recommended by some of the PNM witnesses that consolidating those would have a better chance of getting more favorable bonds because of the combination, if you like? In your experience, do you think that's a viable argument or not?
I do. I mean, that's really not my particular area of expertise, but from what I've seen, generally the larger issuances have lower unit costs for issuance and type of transaction cost. So I think that to the extent that you can issue a larger bond issuance, it's probably in the ratepayers' benefit to do so. I do, though, think that there should be some recognition then of the delay with regard to the first unit that would be abandoned under the current plan. That would be unit 1, and that ratepayers should again be compensated for, let's call it a 3-month delay in terms of waiting until that second unit is abandoned and the bonds are issued. And of course, if the bonds are not issued upon abandonment of the second unit, my testimony is that ratepayers should be compensated for that entire time differential.
Do you have, again, based upon your experience, any sense of what the magnitude would be in either percentage or in real terms with regard to separate securitizations, with regard to just the processing and the financing costs of the securitization if it were broken up into two pieces?
I don't.
I'm sorry. I'll try one more time. I know you had in your procedure order specifically laid out a prohibition against friendly cross. Well, Mr. Albright characterized this as questions for clarification. We all know what his client's position is, and I don't know that this seems to be friendly cross.
Mr. Albright, what are you doing here?
Mr. Hearing Examiner, I'm simply, we have the potential between having a single securitization at the abandonment of one plant. We have the potential for two. I'm just, it's with respect to where she talks about her, just had the page, with regard to on page 16 about by definition isolates a single special rate making treatment. I'm trying to get a sense for what her opinion would be as far as the impact on the consumers if we end up with multiple abandonments between units 1 and 4.
I'm going to overrule it. Go ahead, Ms. Crane.
Okay. I really don't have a good sense of the quantification there. I mean, obviously there are things like rate cost to rate the bonds. There are documents that have to be prepared. It seems to me, to the extent that you can do those things once rather than twice, you would save those transaction costs. Now, whether you would cut your costs in half or not, I don't know. Many times I've seen these bond transaction costs be expressed as a percentage of the issuance. So my guess, though, is that actual percentage changes depending on the size of the issuance as well. So, a larger issuance may actually result in a smaller percentage transaction cost, i.e. a savings then to ratepayers. But in terms of the actual magnitude, I don't really have an estimate as to what that savings might be and whether it might be material or not.
Okay, well, thank you very much, Ms. Crane. Mr. Hearing Examiner, that's all the questions I have from Ms. Crane. So thank you very much. Appreciate it.
Thank you, Mr. Albright. Let's see. I believe that's. Let's check if staff requested anything. No. So that's it for the cross-examination requested of Ms. Crane. Hearing Examiner Chamanauer, do you have any questions for Ms. Crane?
No, I don't. Thank you.
Thank you. I do have a couple. Let me pull up a witness that Ms. Crane. Good morning. It's nice to have you again as a witness and to see you, Ms. Crane.
Thank you. Nice to be here.
I want to ask you about some of the testimony that a witness who may testify later today for Pnm, Laura Sanchez, testified to in her rebuttal testimony. And I would like to turn your attention to, I don't know if you have a rebuttal testimony, you may not need it. I'll just quote.
I do have it.
Okay. Let's look at page 26 first. I'm using her testimony. She's talking about Pnm witness Stetledge's testimony there about the roller coaster effect for customers where their rates go down. This is started on line 14, but I'm on line 16 now. Roller coaster effect for customers where their rates go down for a short period of time and then go up significantly once the rate case is approved. The ETA charge is imposed and the rate credit falls off. Is that what you were addressing with Mr. Marks?
Yes, absolutely. That's why I indicated that the commission may believe that a regulatory asset is preferable to an immediate rate credit. I mean, I'm sorry, I'm doing the same thing that Mr. Falgren did in his email, a regulatory liability, not a regulatory asset.
In your considerable expert opinion, though, are there any tools that the commission could use in the rate case to smooth out that roller coaster effect if a rate credit were ordered?
Well, I think the concern with regard to the roller coaster is not what would happen in a rate case, it's what would happen prior to the next rate case. So I think what
Right.
Ms. Sanchez is saying here is that rates would go down now, and the commission, presumably rates would go back up again when the company has a rate case. And so that's the roller coaster that I think she's referring to. Obviously, the commission can do a lot of things in the next rate case to prevent this roller coaster effect by changing the amortization periods, for example, of a regulatory liability. But once you implement that rate credit, there isn't really much that you can do until the company actually does file its next base rate case.
So it could lead to rate shock down the road, a rate credit.
I mean, it could. We don't have any idea really what's going to happen in Pnm's next rate case. I mean, maybe they will not get any rate increase, any additional incremental increase. So I can't really say whether there's the potential for rate shock or not. But I mean, it is something that we always worry about. With a regulatory asset, you're keeping rates where they are now. You're accruing a regulatory asset with carrying costs, so you're keeping the ratepayers whole. And then you can see, let's say, for example, that you build up, regulatory liability. Let's assume that Pnm, you find that the regulatory liability is the way to go. Now you're in a rate case. Okay, well, you can, first of all, you'll know then what type of overall level of base rate increase the company is requesting and what level you are approving. And that can then help you to determine an appropriate amortization period for that regulatory liability. So you have sort of a multi-year view at that point that you really don't have sitting here today.
Okay. Now, let's look at page 22 of our rebuttal testimony.
Yes.
Ms. Sanchez argues that the question on line 11 starts, does the proposed rate credit comport with the regulatory compact, in her opinion? And she asserts, starting on line 17 below, that the measures urged by the party's testimony to remove a single asset from rates, San Juan, suspend the regular order and change the regulatory paradigm midstream without any authority of the ETA, and are in express contradiction to past commission practice that such single issue rate making is disfavored. Do you agree with that assertion?
Well, I agree with some of it, and with some of it I disagree. First of all, it is single issue rate making. As I say in my testimony, I agree this is single issue rate making. And I think we ought to just all acknowledge that, number one. Number two, I have a long history. I've been doing this for 30 years, and I've always taken the general view against piecemeal rate making. However, there are situations where, by definition, you have piecemeal rate making. You have fuel clauses. You have, renewable portfolio standard clauses. You have energy efficiency clauses. In this case, you have one asset that is going to be securitized. And so that kind of overcomes the prohibition against piecemeal rate making.
And why would the asset be securitized?
The asset would be securitized because the ETA allows it to be securitized.
And because the utility that owns the asset filed an application requesting that it be securitized.
Sure. I mean, Pnm made the decision as to how they wanted to handle these stranded costs. And I think in terms of her comment that you're doing this without any authority in the ETA, I read Ms. Sanchez's rebuttal testimony, and she talks about the fact that the ETA, neither the ETA nor the financing order grant the commission the ability to have any kind of a rate change prior to the issuance of the bonds. And first of all, I don't think that's surprising, because the financing order and the ETA, they are the two principal documents. As Ms. Sanchez says herself on page 19 of her testimony, these are basically the two principal avenues for securitization. This is what you need to securitize something. You need a financing order and you need the legislation allowing you to do it. One should not expect that either of those documents would attempt to address every other single situation that may arise, right? These address securitization. They don't tell you what happens if the company doesn't securitize. In my view, the commission, as long as it doesn't expressly violate a term that's in the ETA and the financing order, the commission has its ongoing regulatory authority to take whatever steps it believes are necessary to ensure just and reasonable rates. So unless there was a red sentence in the ETA that said the commission cannot order a rate credit in the event that we delay securitization, the ETA is silent on what happens in the situation that we're facing right now. On the other hand, and so is the financing order, although the financing order it is more explicit. You have the 4 events that are outlined in the financing order. You have your recommended decision, which approved the financing order, along with the verbiage we went over yesterday that links abandonment with issuance of the bonds. So I just think that we need to take maybe a little bit broader look at this entire situation instead of getting so hung up on the exact words of the ETA, because I think you absolutely have the authority to do what is being proposed in this case. And I should end by saying I'm not an attorney, so that's my non-legal opinion, obviously.
Fair enough. Thank you so much, Ms. Crane. Mr. Elliott, do you have any redirect? I don't think there's any redirect to be required, but do you have any?
No, I do not. Thank you, Mr. Hearing Examiner.
Thank you, Mr. Elliott. Ms. Crane, as always, it's a great pleasure to have you as our as a witness.
Mr. Medeiros.
Mr. Michael.
Yes, I did have 2 quick follow-up questions to the questions you were asking, if I might be permitted to do that.
Sure, go ahead.
Okay, thank you. Good morning, Ms. Crane. Nice to see you again.
Good morning, Mr. Michael.
Would you agree that the issue of whether or not a rate credit or regulatory liability should be imposed at the time of abandonment or at the time of the ETC was fully litigated in the earlier portion of this case and resolved?
I believe I would say yes. However, I would just caveat that by saying we were given various assumptions in that earlier phase of the case that we're now told no longer apply. So there's a little twist to that.
Mr. Michael?
Well, the amount of the rate credit.
Mr. Michael, I have one question before you ask your next question.
Sure.
I'm not trying to interrupt you. It just the transcript says at the time of the AEDC. What did you say there? I couldn't quite capture it.
Oh, what did I say, Mr. Medeiros?
Yeah, should be imposed at the time of the ADEC was fully litigated. What was the acronym you used there?
That was not, it wasn't that.
Right.
It was either at the time of abandonment or the ETC.
Energy transition charge.
Yes.
Energy transition charge, right?
Yes.
Okay, I just wanted the transcript to be clear on what you were referring to there. Go ahead, your next question.
Thank you, Mr. Medeiros. The amount of the credit that was determined in the earlier part of this case was roughly 94 million, and now it's 98 million. So that hasn't changed appreciably. Is that right? If you
Right.
know.
And
Okay.
yeah, and I think
And
Mr.
if-
Monroy indicated it would be $98 million. Yes, yesterday he
Okay.
indicated it would be 98 million. And can I just clarify one thing though? When you just had your discussion with Mr. Medeiros, I thought I heard in the first question you asked me was the issue of abandonment and issuance of the implementation of the ETC litigated. And I said, yes, but the twist here now is that the company is trying to disaggregate those two events. I just want to make sure that you understand that was my response to your first question.
Okay, let me, so this has gotten, let me just clarify the question so everybody's, so we know what's asked and what's answered. The question was, at the time of abandonment and ETC imposition, and let's assume those occur together, the issue of whether customers should receive a rate credit or a regulatory liability was fully vetted and litigated in the earlier part of this case, right?
Yes.
Okay, thank you. And my next question is, let's assume you returned something to REI. Would you rather get cash or a store credit?
I don't even know what REI is, but
Okay, let's assume you returned something to Dillard's.
that I'm familiar with.
Okay.
Well, I generally in my experience, you get either a store credit or you get a credit back on your credit card. You generally do not get cash.
My question was, which would you rather get, not which, what do you get? Wouldn't you rather have the cash?
Sure. I
Okay,
would
thank you.
always much rather have the cash. Yes.
Okay, great. Thank you. That's all the questions I have.
Thank you, Mr. Michael. Mr. Scheinauer, anything?
No questions.
Okay. All right, Ms. Crane. Again, thank you so much. It's great to see you. Appreciate your testimony, and you are excused.
Okay. Thank you. And thank you for accommodating me this morning. I appreciate it.
Of course, as
Thank
always.
you.
Thank you.
Okay.
Okay, Ms. Twilliger, I'm going to go ahead and grant I didn't anticipate us getting done quite so fast with Ms. Crane. And so we're ready to move to our next witness, Pnm's witness. And we need to do a shift. So go ahead and I guess we need 5 minutes. Is that right? Please unmute yourself.
Sorry, I thought I had. It looks like Mr. Alvitris is already in the meeting, so.
All right, well, I have a ruling on Nmprc's motion in limine regarding certain Pnm rebuttal testimony. And while we're getting the next witness ready to testify, I will issue the ruling, if that's all right with the parties. All right, very well then. We have before us Nmprc's May 20th, 2022 motion in limine and Pnm's response to that motion, seeking to strike certain Pnm rebuttal testimony. Having considered the pleadings, first, as to striking the rebuttal testimony of Pnm witness Monroy and Sanchez under the doctrine of res judicata, the hearing examiners find, as they did in the May 20th pre-hearing order in the context of similar arguments made by Nmprc in seeking to strike certain direct testimony of Pnm witnesses and Pnm's legal memorandum, that it would be inappropriate to resolve the issues presented in the underlying joint motion for order to show cause, and those Pnm was asked to address in attachment 1 to the April 1, 2022 procedural order in the posture of a motion in limine striking witness testimony addressing core issues involving the interpretation of the financing order and applicable provisions of the Energy Transition Act. Once again, res judicata cannot operate to prevent PNM from introducing its evidence and arguments on those issues, because that would clearly prejudge the question of whether PNM must issue the energy transition bonds and provide a customer rate credit or some other form of remedy, at the same time San Juan plant abandonment is completed, as opposed to at the time the energy transition charge becomes effective. Second, as to New Mexico area's argument that certain Monroy rebuttal testimony be stricken on relevance grounds, while this ruling should not be construed as commenting on the probative value of any particular piece of evidence, the testimony at issue is sufficiently relevant to be admissible under the Commission's relatively relaxed evidentiary standards, and the introduction of such testimony will certainly not prejudice any party to the proceeding. And at any rate, as PNM acknowledges in its response, the hearing examiners are free to give the testimony the weight it deserves. Third, as to New Mexico area's argument that certain rebuttal testimony of PNM witness Sanchez constitutes improper expert witness testimony in the form of legal argument and legal conclusions, the hearing examiners find it would be inappropriate to strike testimony that specifically responds to extensive legal testimony and opinions proffered by several parties opposed to PNM's position in this case. As this hearing examiner found in a similar context in case number 21-00017-UT, although PNM witness Sanchez undoubtedly expresses legal opinions in a rebuttal testimony, she is doing so in response to legal opinions given by joint movement and intervener witnesses in their testimony. Ms. Sanchez also appears sufficiently qualified to testify as an expert in regulatory policy centered on matters like application of the Energy Transition Act to the facts of this case. She is certainly no less qualified than some of her counterparts rendering legal analyses in joint movement and intervener testimony. In short, the hearing examiners will give all the testimony offering legal opinions or mixed regulatory/legal opinions in this proceeding the weight such testimony is due. NM area's motion in limine, therefore, is denied. The hearing examiner's ruling notwithstanding, speaking one last time about giving testimony the relative weight, if any, it may be due, regarding Ms. Sanchez's rebuttal testimony that endeavors to divine or suggest the legislative intent underlying certain provisions of the Energy Transition Act, grounded specifically in her involvement in drafting and passing the ETA, as described, for instance, on pages 3 and 14 of her rebuttal testimony. The hearing examiners observed that the New Mexico Supreme Court has stated on more than one occasion that it refrains from inferring legislative purpose or intent based on quote unquote legislative history. As far back as 1998, the Supreme Court stated in Regents of University of New Mexico versus New Mexico Federation of Teachers, specifically in paragraph 30 of the court's opinion, that quote, unlike some states, we, the justices or appellate courts in New Mexico, have no state-sponsored system of recording the legislative history of particular enactments. We do not attempt to divine what the legislators read or heard at the time they enacted a particular item of legislation. If the intentions of the legislature cannot be determined from the actual language of the statute, then we resort to rules of statutory construction, not legislative history, end quote. Thus, as the Supreme Court more recently explained in the 2021 State v. Vest, VEST decision, specifically in paragraph 34, the court relies, quote, on the language of the statute as passed and the history of the statute insofar as any amendments have been made. We consider the history and background of the statute, not the legislative history of a bill's enactment before it became law. Very well then. Is Pnm prepared to call its next witness, Mr. Alvidrez?
Mr. Hearing Examiner, we have Mr. Terry. I think he's actually being called by New Energy Economy and WR.
Oh, fair enough. I'm sorry. Not the natural order of events and usual hearings before the commission, and apologies for that. Yes. New Energy Economy, would you please call your Pnm witness?
Thank you, sir. Can I ask a question first? Are you going to be issuing your ruling separately than just your articulation in the record?
I'm not sure what you're asking.
Well, the NM area, you're ruling on the motion in limine?
That was my ruling.
No,
From
I
the
understand.
bench.
Okay, so you're not going to issue a separate order on that. That's all I was asking.
Nor did I in 2117 in similar circumstances involving another party with which you are very familiar.
Yes. Okay, thank you.
You're welcome.
Mr. Terry, good morning.
Good morning.
Could you please state your name and spell it for the record?
It's Joseph
Excuse me,
Donald.
excuse me, this is Ashley Shiner. Could we swear in the witness first?
I was going to do that
Thank you.
next, but sure. Thank you.
Thank you. Raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Thank you.
Thank you. Can you please state your full name and spell it for the record?
It's Joseph Donald Terry, JOSEPHDONALDTARRY.
And sir, people in Pnm refer to you as Don Terry. Is that correct?
Yes, ma'am.
Before last Thursday, could you tell us what your position at Pnmr was?
It was the Senior Vice President and Chief Financial Officer for Pnm Resources.
And you earned that title in January of 2020?
Yes, ma'am.
And on Thursday, something new happened. Could you tell us about that?
I was promoted to President and Chief Operating Officer of Pnm Resources.
And what does that mean that, how does that relate to Ms. Vincent Colon?
I will still report to Ms. Pat Vincent Colon, our CEO. I will not be the Chief Financial Officer, so that will report directly to Ms. Colon, not to me. I will have operations, I will have HR, I will have environmental services, and I will have IT.
And who is the new Chief Financial Officer?
Miss Elizabeth Eden.
And before she was the Chief Financial Officer, she was the Treasurer, was she not?
She was the Vice President and Treasurer of Pnm Resources. Yes, ma'am.
And she, in that capacity, when she was the Vice President and Treasurer, she reported to you. Is that correct?
Yes.
You are part of the Executive Policy Committee. Is that also right?
That is correct.
And who, could you please state who are the other members of the Executive Policy Committee?
Pat Vincent Colon, our CEO, Charles Eldred, he's our Executive Vice President of Finance, myself, Ronald Darnell, who's our Senior Vice President, Public, I think it's Public Affairs, if I don't have his title right. It would be Chris Olson, our Senior Vice President of Operations, and Patrick Apodaca, who is our Senior Vice President, General Counsel. And now it'll include, as of Monday, it'll include Miss Lisa Eden as well.
I'm going to ask you some questions about your role as the CFO, your role prior to Thursday, if I can. As the CFO, you reviewed and are familiar with all the long-range plans presented to the Board of Directors, correct?
Yes, ma'am.
Sir, do you have New Energy Economy's exhibits? Could you please open NEE SC4?
Now, Ms. Nanazi, now that you've introduced the witness and started a dialogue with that witness, I'm assuming we're into your 70 minutes, correct?
Yes, sir.
Okay.
NESC 2-4.
And you recognize this, that this is the proxy statement that PNM Resources submitted to the Securities and Exchange Commission on January 5th, 2021. Is that correct?
Can you quote it one more time? I'm sorry. I'm at SC 2-4 and it's something. Is that where I'm supposed to be?
Yes.
I have
No, not 2-4, just 4.
just 4. Sorry. Okay.
Do you see it? If you
Yeah.
have that in the book, it's probably at the end.
Yes, ma'am.
Okay, so did you see that I submitted, just for the party's purpose, yours included, the full document of the PNM Resources proxy statement made to the Securities and Exchange Commission as NEESC4A, but I'm asking you to look at just the one that's 4. The 4A is the entire document, but I just put the certain pages that I'd like to move into the record ultimately after into 4. Do you see that?
Yes, ma'am.
Okay. Could you please turn to PDAF page 4 of this document, which is actually on the proxy statements, page 45. On August 25th, 2020, Ebidrol and Evangrid provided an executive indicative offer letter which contained terms to merge with Pnm'S. Is that correct?
An executed indicative offer bid. I think it's on August 25th, 2020, Ebidrol Evangrid provided an executed indicative offer letter. Yes, ma'am.
And that contained the terms to merge with Pnm'S.
Yes, that wouldn't have been the terms. That was an indicative offer bid, that a letter that would have laid out certain parameters. The actual merger agreement wouldn't have came along until October 20th.
Correct. That's what I was going to ask you next. So PNM and Evangrid and New Mexico Green Holdings entered into an agreement and plan of merger on October 20th, 2020. Is that right?
Yes, ma'am.
And in the merger case 20-00222 UT, could we refer to that as the merger case? Would that be fair?
I would prefer that more than the numbers. I get lost in the numbers, so.
Okay. So in that case, those parties were known as joint applicants, correct?
Yes, ma'am.
If you could turn to PDF page 14, and on the bottom of it, this is document, it says 100. And so the original termination or end date as part of the agreement and plan of the merger was January 20th, 2022, correct?
Correct. And then it had a 90-day extension, so it could be extended out to April 20th of 2022.
And PNM and Evangrid and the other joint applicants extended the merger contract beyond the date that appears in this proxy, and that was until April 2023. Is that correct?
Yes, they would have done that in, I believe, in the January timeframe of 2022. So
In October 20th, in October 2020, the P&M board agreed to go forward with the merger pursuant to the agreement and plan of merger with Evangrid, and Evangrid was to pay an all-cash transaction of $50.30 per share to purchase Pnmr. Is that correct?
Yes, ma'am.
And if you could go to page 71 of this document, just the page before that. Upon completion of the merger, you, sir, which at the time this was written, was P&M's chief financial officer, you would serve as president and chief executive officer of Pnmr, which would be wholly owned, which would have been a wholly owned subsidiary of Evangrid. Is that also true?
Yeah, on the conclusion of the merger, if the merger would have closed, I would have been the chief executive officer of P&M Resources.
In January 2021 of last year, your base salary was $418,000 per year, correct?
That's what I believe, yes.
Mr. Hearing Examiner, I object. The questions about compensation are not relevant to the issues in this case. And nor is Mr. Terry's among the officers at P&M Resources whose compensation is made public as part of SEC filings. He does have a right and expectation of privacy in these matters.
Ms. Zanazi?
A couple of things. One is, I believe that he is a senior officer, and senior officers have, as you can see from the page right above this one, have their salaries listed publicly to the SEC. So I don't know that they do have a privacy interest. That's one. But two is, I believe that there's a question about the personal interest, bias, credibility, and motive of this. And I have like two more questions on this, and then I'm going to be moving on. So that is my answer.
Objection overruled.
Sir, if I may, if the merger with Evangrid was approved in December 2021, you were going to get a promotion. Is that right?
Yes, I would have became the president and CEO of P&M Resources.
And you would have gotten a salary increase. Is that right also?
I would hope, but nothing was set.
And that's because the merger was rejected by the PRC. Is that correct?
There was no set compensation prior to the merger. I mean, once the merger would have closed, then, I would have probably figured out my salary at that point in time.
Was there an agreement between joint applicants pursuant to the agreement and plan of merger that P&M stock had to be at a certain price or not fall below a certain price?
Are you saying that, and it was hard to follow your question. Are you saying after the merger was signed or before the merger was signed, or?
After the merger was signed, but until its final execution?
Not that I'm aware of.
Is it true that P&M's 2020 strike that. It's true that P&M's 2022 earnings guidance range includes continued rate recovery for San Juan Generating Station after the plant closes, meaning that base rates stay in place?
Our 2022 operating plan does include base rates staying in place.
Which also includes that rate recovery for San Juan also stay in place.
It includes our base rates stay in place.
So is that a yes, sir?
Yes, it includes our base rates. The current rates in place approved by the commission stay in place.
Is it also true that P&M's 2022 earnings guidance range does not include the issuance of energy transition bonds?
That is correct.
Although you were CFO, you were unaware of the impact that a commission ordered full revenue requirement adjustment for San Juan would have on Pnm's 2022 annual earnings.
Was that a question or a statement?
Is that correct?
I wasn't 100% sure what the specific impact would be, because you've got to see what the case kind of comes through and looks like. So, and then what the final order would say based on that. So, I mean, I think Mr. Monroy in his testimony lays out, you know, what the impacts would be of a full revenue requirement adjustment for that.
What is that per year?
I believe that he testified yesterday, it was $98 million a year. Subject to check. That's what I remember. I believe he said.
And when you gave your deposition a couple of days ago, on May 18th, you didn't know the specific number of if the commission ordered a full revenue requirement adjustment for San Juan. Is that correct?
That is correct, because I was confused between, and why I answered that way was there was a change between those numbers and I didn't have the final number associated with it. And so I think I actually deferred to Mr. Monroy in my deposition saying he would have that number.
If the commission orders a full revenue requirement adjustment for San Juan, how will that, strike that. If the commission orders a full revenue requirement adjustment for San Juan, that will impact Pnm's 2022 annual earnings, correct?
It would impact our earnings associated with whatever change was made. Yes.
I am now turning to the deal model. Is it true that the deal model was the finance?
Can you point me to where that's in here?
I'm just asking a question first. Is it true that the deal model was the financial model that was provided to Evangrid that was memorialized in the proxy and would have included Pnm's base plan and projected revenues?
If you're referring to the DIL model, the one that was produced in August of 2020, I believe so.
Thank you, sir. Could you please now go to page on this document that we have open? It is page 53. So that is
talking about NEESC-4.
Yes, sir.
Now, while Mr. Terry's taking a swig of water, this document that I just downloaded from Dropbox is not labeled.
I believe, oh my gosh, I don't even know how that happened. That's not what I have on my computer. I am extremely sorry because I don't know how, when it transferred. I will make sure that that is changed. I apologize. I was so proud of this document. I thought that I'd have no issues, but I
just ask all the parties again to take one last look at this. I spent time last night trying to help the court reporter with this because of the confusion, and let's all try and get on the same page with this. I'm not directing this particularly at you, Mr. Nazi, because it's not just you, but let's all get these documents labeled correctly.
I'll be sure to do that. I'm very sorry.
Thank you. Ma'am.
So are you at what's labeled page 53 of this document of the proxy statement, sir?
Yes, ma'am.
Okay, so when Pnm was producing the final financial forecasts for Evangrid, there were a number of assumptions regarding Pnmr revenue forecasts. Is that right?
Yes, I mean, every forecast will have assumptions in proxy. There are assumptions based on what you would assume to happen.
So I'd like to just go through these with you. And they included at that time, it says here in the proxy that the forecasts set forth above assume no significant change in regulatory framework, including assumptions relating to rate cases in Texas and New Mexico. Decoupling revenues are in place. Each of Pnm and Tnmp earn a certain targeted return on equity. The Pnm securitization is implemented in 2022. Planned capital expenditures and their net customer impacts. Retirement of San Juan Generation Station as previously disclosed. Divestment of Four Corners as previously disclosed. Return of Palo Verde leases Unit 1 in 2023 and Unit 2 in 2024 as previously disclosed, and three other assumptions. Is that a correct statement?
Yeah, there was three assumptions you didn't read in the list, so that were highlighted. There was the normal weather consistent with historical usage and other assumptions affecting customer demand, annual FERC transmission rate increases at Pnm, and issuance and conversion of mandatory convertible securities to be issued in December of 2021 and converted in December of 2024.
The expected earnings from these sources of revenues determined the valuation of the company and the transaction price, correct?
The valuation is determined. It's determined by, in the way that investment bankers do this is they look at a lot of different factors. So they look at projections. Some of them are projections of 5 years. They look at peer market analysis. They look at DCFs, discounted back. And a lot of them look at a longer term than just the current term. So, it's all those factors that go into it. This would be the model that they have. And the reason why these assumptions are in here is this is a public document and this is a forward-looking statement. So you've kind of got to lay out what you assumed in those numbers, given it's a forward-looking statement.
Can you now turn to New Energy Economy SC 2.1, please?
SC 2-1.
Correct. This is properly labeled. This was also something that we discussed in your deposition and it was referred to there as NE Exhibit 1. Do you remember that?
Yeah, this is the 2021 to 2024 long range plan update that was to the board of directors on March 5th of 2021.
Mr. Nazi,
Yes, sir.
this is labeled NEE Exhibit 1. There's already an NEE Exhibit 1. Oh, it's labeled right. I'm sorry. Strike that. Apologies. Go on.
Thank you, sir. This document was presented by you and the other members of the EPC to the board of directors on March 5th, 2021, and that was before the merger hearing. Is that correct?
That would be correct because the merger hearings, I believe, were in August of 2021. Yes, ma'am.
Thank you. Could you please turn to page 2 of 18?
Okay.
P&M states that the deal model was updated to include, for instance, quote, firm plans, unquote, for an exit of Four Corners. That was because P&M had just filed its abandonment and securitization application in January 2021. Is that correct?
Subject to check. I don't know when we filed our abandonment case, so.
If you could go to page 12 of this document, sir.
Yes, ma'am.
So this is the detailed assumptions of the changes between the August 2020 deal model that we've just been speaking about and the 2021 LRP, which stands for Long Range Plan. Is that correct?
That is correct.
And sir, do we see that in the first box of this graph or table, is that, for instance, in August 2020, the company expected revenues in 2021 of 15.9 million and 2022 of 7.9 million for decoupling revenues?
That would be what was forecasted back in 2020. Yes, ma'am.
And shown on this page is P&M's expected revenues of for two rate cases. Is that right? One in 2022 and one in 2024?
Yes, there's a P&M rate case in 2022 and a second rate case in 2024 in both models.
And in the 2022 rate case, P&M had assumed that in 2020 that it would ask for $22.7 million that would be implemented in July 2022. And then in the 2021 update, that increased to 35.6 million, but also to be implemented in July 2022.
Correct.
And in this March 21 Board of Directors long range plan, it was still the company's position that it was going to issue secured energy transition securitized bonds beginning in July of 2022. Is that right?
Yeah, that was what was assumed in this long range plan. Correct.
At the bottom of this page, there's a column that's entitled PV leases, and that's Palo Verde Nuclear Generating Station. Is that correct?
That would be the Palo Verde nuclear generating leases that we had. Correct.
And thus, and originally in 2020, P&M thought that it was or expected to earn revenues of $110 million from leasehold improvements. And in March of 2021, it expected to have revenues of $95 million from the leasehold improvements, correct?
I wouldn't classify them as revenues. I think those are rate-based numbers, but I think those are what's the leasehold improvement rate-based numbers that exist.
So now, if you could please, sir, go to a different document, and that is NEESC 2-2. It's the very next document.
Okay.
Now, sir, the first document that we have just been talking about was March 2021, and that was before the merger. And this is a document that's the updated long-range plan 2021 to 2025, August 31st, 2021, correct?
Yeah, one clarification would be, you said merge prior to the merger. It was prior to the merger hearings. The merger had already been, entered into. It was prior to the hearings.
Thank you so much for that clarification. So this was submitted to the board of directors, essentially at the close of the merger hearings, correct?
I believe so. My only question is it doesn't say board of directors update. So, I mean, I'm assuming, but it doesn't say board of directors. Most of the time they say board of directors update on the cover sheet. So, but I'm assuming.
Thank you, sir. Could you go to page 2 of 4?
Okay.
So this is a document that states key updates. And it says here, adjusts timing of P&M rate cases. Next general rate case delayed 1 year due to merger. Issuance of San Juan securitization bonds delayed to coincide with general rate case. Rate riders implemented to provide rate path through generation transition period and avoid back-to-back rate cases. Did I read that correctly?
Yes, you did.
So as a result of the merger, this document is the first document that at least the parties have that indicate that the securitization bond issuance has been delayed. Is that correct?
I think what drove this document being updated was in the merger hearings. I believe there was intervener parties that wanted a rate freeze till June 1st of 2022. So naturally, if you have a rate freeze, I think that was in Mr. Darnell's rebuttal testimony. I think if you have a rate freeze till 2022, then everything moves out 1 year.
So, sir, have you read Mr. Darnell's, I think it was July 29th testimony in the merger case?
I would have read it. It would have been back then. I haven't read it recently.
There was nothing in Mr. Darnell's testimony that indicated that the securitization bonds would be delayed as a result of a delay in a rate case, was there?
I wouldn't know. So I haven't read it in a long time. So
You've also never read the ETA.
I've never read the ETA, have not read the financing order to this case. I have not, I wasn't a witness in the abandonment filing on this. So that is correct. And that's what I mentioned in my deposition.
P&M did not notify anyone that the issuance of the San Juan securitization bonds were going to be delayed other than Pnm'S board of directors, members of the EPC, and a few others at P&M. Is that correct?
Not that I'm aware of, no.
P&M did not communicate the bond issuance delay to any of the signatories to the merger.
Not that I'm aware of. I mean, from my perspective, they were always linked together. So
P&M did not communicate the bond issuance delay to the PRC.
Not that I'm aware of.
P&M did not consult with anyone before it changed the date of the energy transition bond issuance from July 2022 to July 2023.
We've always assumed that they go together. And so not that I'm aware of. I mean,
P&M did not notify anyone outside of P&M or Evangrid of this energy transition bond issuance change.
Like I said, we've always grouped them together. So not that I'm aware of.
The P&M EPC or Board of Directors did not calculate the financial significance of the energy transition bond issuance change from July 2022 to July 2023 to ratepayers. Isn't that right?
Not that I'm aware of. No, I don't recall seeing any there. Again, I think, my belief is they were always grouped together. So they're the rate case and the securitization, issuing the securitization bonds.
No securities firm or financial analyst of any entity outside Pnm or Evangrid was consulted about the change in date of bond issuance and the impact it would have on Pnm ratepayers.
I'm not aware of any, no.
You don't remember any member of the Board of Directors raising any question about the decision to shift the issuance of the bonds from July 2022 to July 2023, do you?
No, because I think the belief has always been that the rate case and the securitization bond issuances are linked together.
Sir, would you please turn to New Energy Economy SC-23, the very next document. And this was the document that we discussed also at your deposition last week. Do you see, is it correct to say that this is the 2021 to 2025 PNMR standalone long-range plan that was presented by you and the other members of the EPC to the Board of Directors on September 20th, 2021?
Yes, ma'am.
Sir, could you please go to page 3 of that document, page 3 of 13?
Okay.
At the top here, it says that earnings per share growth lags March 2021 long-range plan due primarily to the merger, which delayed the PNM rate case by 1 year. That was because the PNM rate case was delayed from 6/20/2022 to 7/2023. Is that correct?
I believe so. I was looking for the assumptions, but I believe so. It was delayed 1 year. Yes.
The Board of Directors also discussed the possibility of applying for rate riders instead of back-to-back rate cases. Is that also true?
That was what was baked into the model. Yes, that's what it says. There's a potential new rate rider strategy as part of the 2023 rate case to provide a path through generation transition period and avoid back-to-back rate cases. So,
could you turn to the next page, which is page 4 of 13, please? And this says again that the EPS, or earnings per share growth, was lower due to the delay in the PNM rate case pending the merger approval. Is that right?
correct. I mean, yeah, correct. Customers are receiving benefits of the delay.
Could you look at page 8 of 13? I'd like to focus your attention, sir, in the third bullet. Can you please explain why PNM believes that it will minimize regulatory lag and earn an authorized return when there are changes to New Mexico regulatory environment as Nmprc moves from a 5-member elected commission to a 3-member appointed commission in January of 2023?
You know, I think the minimized regulatory lag had to do with the potential of putting rate riders in place. That would be the way that you would remove regulatory lag, similar to what we see in Texas with types of costs that are associated with there, where you have interim relief, and you don't have to go through the whole rate case process.
And I believe that you testified at your deposition that it's your belief that the rate rider in Texas, which I think you just referred to, specifically for transmission and distribution, is equivalent to a piecemeal rate making.
I did, yes.
Could you please turn to page 9 of 13? The next page. There are a number of challenges of a standalone plan to be mitigated by the merger with Evangrid, including Pnm'S ROE, the Four Corners case, and recovery for Palo Verde lease improvements. Is that what this page says?
Going to object. It mischaracterizes what the page says. It's nothing to do with Evangrid.
I believe if that's true, then Mr. Terry could correct me if I'm wrong.
Just rephrase the question, Ms. Nazi, please.
Thank you. Standalone refers to P&M without Evangrid. Is that correct, sir?
That is correct. It would be P&M without Evangrid as a standalone business continuing to run like it does today.
So I'm going to ask you the question again. There are a number of challenges of a standalone plan to be mitigated by the merger with Evangrid, including P&M's ROE, the Four Corners case, and recovery for the Palo Verde leasehold improvements. Is that correct?
Same objection. There's no reference to Evangrid.
There is no reference to Evangrid, Your Honor, but I just asked him about standalone. He said that this was without the Evangrid, and so that's why I just asked him that.
Objection overruled.
So these would be challenges that exist as a standalone business operating as P&M Resources.
P&M applied for Four Corners abandonment and securitization before it filed a rate case to avoid a Four Corners prudence review. Is that correct?
No.
Sir, could you please go to SC 2-4?
Okay.
This is the 2022 annual operating plan for P&M Resources. That was a board of directors presentation on December 3rd, 2021, correct?
Yes, a 2022 annual operating plan, which is 1 year out, is what it's considered for P&M Resources. And yeah, it was December 3rd of 2021.
Can you go to page 2 of that document?
Okay.
The last bullet here says that P&M anticipates filing a general rate case in December 2022 with rates effective January 2024. That's correct?
That is correct. Yes.
This is after the hearing examiner's certification of stipulation in the merger case, but before the PRC decision in the merger case, correct?
I believe so. Yeah, looking at the date.
That was another change from the former or the previous board of director presentations, correct?
Correct. It was driven by the recommended decision, which denied the merger, but did say if the commission desire to approve it, that the stip that the hearing examiner would include this additional 6-month extension.
P&M delayed the issuance of the energy transition bonds once again when it decided to delay the rate case another 6 months, correct?
Correct. We see them as synced up.
This decision was made either by Evangrid or by Pat Vincent Colon, the CEO of Pnm and Evangrid, correct?
The decisions in this, and I think what you're quoting is my deposition. I got the question specifically in the deposition whether, I was involved in the process, and I said that my involvement was limited to primarily the reliability side and the balance sheet side. And so then you asked me the question of who made the decision, and I deferred. I said I believe the decision was made by Ms. Pat Vincent Colon and Evangrid.
In November, when there was another decision to postpone the bond issuance again, there wasn't any analysis done at that time to determine the financial impact to Pnm or to Pnm ratepayers that would result from postponing the bond issuance, was there?
The financial plan would have assumed the bond issuance being delayed, the delay of the rate case, the benefits associated to the customers of delaying the rate case. So that part of it, I don't know anything about any analysis done on the customer side now.
Pnm has not taken any steps to date to obtain each of the Securities and Exchange Commission and rating agency approvals required to issue the bonds authorized by the financing order in this case.
That's my understanding. I think that's what Mr. Atkins says as well. So.
Sir, could you please turn to Nmprc 2-6.
(2-6).
Yes, sir.
I'm there.
Thank you. So on page 1 of this 18-page document that was an exhibit produced by Pnm exhibit NEE 12-12B. And you recognize this because we discussed it at the deposition, correct?
We discussed part of this email chain at the deposition.
So on page 1, this graph here shows a decrease in revenues by $24 million from the August 2021 model. Is that correct?
Yeah, this would show the impacts of and the customer benefits because you've delayed the rate case by 6 months. So it was a $24.1 million savings to customers by moving out the rate case 6 months.
And this graph shows the further delay in response to the hearing examiner's certification of stipulation. Is that correct?
Yeah, that's what this whole graph. That's what this whole graph shows. It shows the two different models with the 6 month delay from June 1st to December 1st of 2022.
And right above there, there is a question from Elizabeth Eden. First, strike that. This is in response to your request on page 3 of 18. That was on November 2nd, the day after the certification of stipulation in the merger case. At 11:10 in the morning, you ask Henry Monroy and Elizabeth Eden, Tim Nichols, Kyle Sanders, Can someone pull together the numbers from what we would assume if we did the HE rate path compared to the deal model? Need to see the comparisons pretty quickly. And then if you go to page 1, the same day, essentially an hour later, this is the graph that was produced in response to your request, correct?
Correct. Yeah, that's what Kelly produced in response to my request based on the hearing examiner's stipulation.
And in the stipulation, the hearing examiner did not mention that if there was a rate freeze, that there should be a energy transition bond delay, did he?
No, not that I'm aware of.
Okay, so a couple of minutes later, there's a question right above that graph in an email from Elizabeth Eden, the CFO of P&M Resources, to Kelly Alcantar, Alcantar, to you, to Henry Monroy, to Tim Nichols, and Kyle Sanders. And she says, Kelly, does this assume that securitization bonds will be issued when new rates go into effect? Lisa. And then there's an answer above that about 35 minutes later from Henry Monroy. And he responds by saying, sorry, I didn't see this question, but yes, this assumes securitization bonds are issued 1/1/24 with new rates, a 6-month delay from what was assumed in the August 2021 model. Is that correct?
That's correct.
P&M periodically updated the financing models from August 2020 onward to let Evangrid know what the status of P&M revenues were. Is that right?
When we updated models like the long range plan, we would provide them an update at the same time, correct?
And you provided this model that's on page 1 of 18 also to Evangrid, correct?
I would assume it would go in a full model. I don't know when we actually provided a model to Evangrid off of this. So this is an email chain, so.
Is it P&M's position that the financing order doesn't identify a timetable for bond issuance, and therefore P&M is free to decide when to issue the bonds?
Yes, I believe that's what Mr. Monroy testified to.
You believe there was a joint decision made by P&M and Evangrid to postpone the rate case, and because the rate case was postponed, the issuance of bonds were linked in your mind, and they therefore should both be postponed, despite that the PRC was never notified, correct?
Objection compound.
Break up the questions, Ms. Anazi.
You believe that there was a joint decision made by P&M and Evangrid to postpone the rate case, correct?
I think that there was a joint decision based on what the interveners requested and what the hearing examiner put in the stipulation that he filed. Yes.
And because there was a delay in the rate case suggested, and that there would be a delay in the issuance of the energy transition bonds.
Yes, I mean, as I said, we've always seen them sync together.
And that is so despite the fact that you didn't tell any signatories, you didn't tell any stakeholders, you didn't tell the PRC in any filing or verbal communication.
That's my understanding. So,
Sir, could you please go to SC 27? And this is the 2022 to 2026 PNMR long-range plan that was presented to the Board of Directors on March 1st, 2022.
yes, the 2022 to 2026 PNMR long-range plan, March 1st of 2022.
Could you please go to page 11 of 21?
Okay.
No, we discussed.
Excuse me, Mr. Herring-Semmer, could we just repeat the exhibit number, please? From Ms. Nanazi, if she could just repeat the.
I believe she's on NEESC dash 2-7, is that right?
Yes,
SC 2-7.
And this is page 11 of 21.
Thank
And
you.
we-
I apologize. Thank you.
Thank you. The second bullet says, the plan allows for the merger to be successful and close in 2023, while also allowing for investor transparency and confidence that the company remains focused on creating customer and shareholder value and maintaining its investment grade ratings if the merger isn't approved. Is that what this says? And did I read it correctly?
I believe so. Yes.
This is referring to Pnm's financial plan, correct?
This is Pnm's long-range plan that we talked about, correct? So it's a standalone plan that we reviewed with the board on March 1st. So.
In February of 2022, just before this board of directors, you had a conversation with Mr. Azagra Velasquez about Pnm's long-range financial plan, did you not?
I believe we had a discussion about the potential show cause order that there'd been some discussion, I think, between Ron Darnell and Steve Michaels. And so that's the discussion I had with Pedro.
And you
Mr.
knew.
Nazi, could you please spell Mr. Velasquez's name for the record?
Yes, thank you, sir. It's Azagra, last name Blazquez.
Thank you.
Thank you. Mr. Herring-Semmer, how much time do I have?
17.5 minutes.
Since the Evangrid deal was made in 2020, Pnm hasn't earned expected revenues from any rate case, which was expected to be around $50 million. The decoupling case, which was expected to be around $23 million. The Palo Verde leasehold improvements worth approximately $95 million. The $300 million from the Four Corners case, and Pnm has not taken any action towards the securitized financing of $360 million from San Juan, correct?
Objection compound.
Go step by step, Ms. Nanazi, please, very quickly.
Okay, so I'm going to just go back to that proxy statement, if you will. and we could just go through that again very quickly. If you wouldn't.
Can you point me to where that one was real quick? So,
Yes, it's SC-4.
okay.
And if we could go, please, sir, to, it's about the 6th or 7th page, but it says 53 on the bottom. And if we go through these very quickly, Pnm has had no rate case since August 2020. Is that right?
Well, I would start at the first one because I think the first one starts it. So it's the one that you haven't highlighted. So normal weather consistent with historical usage and assumptions affecting customer demand. Clearly, Mr. Monroy talked yesterday, the impacts of COVID and what happened with COVID. So I think that plays a role. I mean, because a forecast is only a forecast. And then, I can tell you the next day, the forecast oftentimes is wrong because something else happened associated with it. So if you go step by step, Ms. Nasi, the first one would be, normal weather hasn't been consistent. We're in a pandemic associated with different usage patterns and so forth.
And so about that, Pnm has made money during the COVID time, right? Quite a bit of money.
Pnm is they haven't exceeded their allowed return. So Pnm did, make their base rates. It shifted between usage. I think Mr. Monroy explained yesterday. But I mean that and weather, and I haven't looked at the weather trends there, but weather plays because we're a KWH business, weather plays a big role. And because of summer rates, weather plays a big role in the summertime. So you'd have to go back and look at each of those factors associated with it.
So let me just ask you that. In 2020, I believe Pnm made $145 million in profits. Is that right?
You'd have to point me to, I don't know off the top of my head. So.
All right. I'll go to that after for a second, but let's put the 2020 and 2021 profits aside for a minute. Pnm has not been able to receive any revenues from the rate cases, at least in New Mexico. Is that correct?
Correct. And I think that's a good point that you're making is, these projections are more than just Pnm retail. These projections assume Pnm retail, assume Pnm'Prc, and assume TNMP. So I think that's another factor that goes into the mixes of things. As you think about how Evangrid would value the business and how things are coming in, you got to look at the whole enchilada. So
yeah, and New Mexico is the biggest part of that enchilada, isn't it?
No, it's been shifting significantly. Texas has been continuing to grow, and I think what you'll see by 2025 is Texas is as big as Pnm retail, and then FERC continues to grow. So I think as you referenced it back in 2005 when we purchased TNMP, that was a factor. I mean, there was a big difference, but Texas, the economy continues to do really well there, and the investments are they invest in their grid there, and they want to invest in their grid.
And but you haven't had the decoupling revenues that you were expecting, right?
That's sorry. Correct. But I would say decoupling is, and I indicated this in when you deposed me, decoupling goes both ways. It's based on usage. So I agree that decoupling revenues that were in the plan didn't transpire because decoupling wasn't approved. And we pulled the case and it required a declaratory order, but decoupling goes both ways. It all depends on what customer usage is.
But at least according to Pnm, Pnm planned to earn revenues of approximately $23 million in 2020 and 2021. Is that right?
Subject to check. I'd have to go back to the sheets that you looked at, but we went through them. So. Okay.
And the Palo Verde leasehold improvements, Pnm has not gotten that $95 million amount. Is that right?
That's currently in base rates. So, I mean, that is already in base rates.
But the leasehold improvements that are specifically articulated in the Board of Directors presentations, the $95 million that PNM was seeking in the leasehold improvements was opposed and right now has not been awarded by the PRC, correct?
But it's correct, but it's in base rates. So,
But the 95 million for leasehold improvements is not. You have not received that chunk of money, and it's being contested. Is that right?
I believe it's being contested, but it's in base rates. I mean, it's not 95 million. It's a 95 million rate base investment. So.
PNM was expecting that in 2023 and 2024, when the units 1 and 2 in Palo Verde, which it would no longer be in base rates, you were going to seek to get recovery for $95 million in leasehold improvements. Is that right?
Correct.
PNM did not receive the $300 million from the Four Corners case, did it? Is that right?
Yeah, that's currently at the Supreme Court. So.
And PNM has not taken any action towards the securitized financing of the $360 million from San Juan. Is that also correct?
Correct. We haven't securitized PNM's San Juan investment.
Has Evangrid sought to renegotiate the price per share that it if it purchases PNM in the future?
Mr. Examiner, I object. We've gone on at length about the Evangrid merger and very, very little about the matters before this commission. And I think we're getting into matters that are far beyond the scope of this proceeding or have anything to do with the financing order or the Energy Transition Act, or any of the issues that have been raised in the case.
Sustained.
Mr. Terry, is this plan by PNM an attempt to make up for the earnings that PNM promised Evangrid was expected, but you haven't made good on?
No.
Is PNM pushing off the energy transition bonds in hopes that the merger will finally go through once there is a new commission and then an Evangrid owned PNM will receive the $360 million?
The $360 million stay at PNM, the utilities. So it doesn't matter who the parent is, but the answer is no. We're not pushing off the securitization. We've aligned it with the rate case.
You don't believe that the current bond market is volatile today, correct?
It's hard to tell. And I think my discussion was, it depends on what you define volatile, and I did reference you to Mr. Atkins, who has far more experience than I do on specifically securitization bonds. The bonds are different and they're based on, how many people are in the market. And, frankly, sometimes they're based on time of day and when you issue it. And a big part of it is if there's a lot of demand for the bond, then you can drive the price down. If there's not a lot of demand for the bond, then it becomes more volatile. But I would defer to Mr. Atkins specifically on securitization bonds.
Sabrina Grinnell, that's Greinel for the record, works in the financing department and reported to Elizabeth Eden, who at that time reported to you in April of 2022. Is that correct?
That is correct.
Could you please turn to NEESC 2-8?
And while he's doing that, while Mr. Terry's doing that, Ms. Nanazi, I'm to let you know you have about 6 minutes left.
Thank you so much. I was just going to ask you.
You're welcome.
I am there, Ms. Minajji.
So while you may not have the expertise in the bond market or to determine whether it's volatile or not, Ms. Grinnell reached out on April 8th, 2022, and sought the advice of a financial analyst at Citi, CITI, regarding indicative securitization bond rates. And Mr. Stefan Lundy.
Going to
I
object.
haven't finished my question,
But
Mr.
Counsel-
Alvidrez.
Counsel is testifying. She hasn't laid, this witness isn't identified as a recipient or an author on any of this email chain. She hasn't identified that he has any knowledge outside of, just being presented this document. And then she's going forth and testifying about who the parties, who everybody is and what they were saying. And there's been absolutely no foundation for the question on this document to this witness.
Tie it up, Mr. Nazi, please.
People under your command at the time, including Ms. Eden, were interested and curious pursuant to the this specific proceeding, about the indicative securitization bond rates. Is that so?
Like I said in my deposition, I wasn't on this email. It looks like it was an email from Sabrina or from Stefan Lundy to Sabrina about bond rates on April 8th.
And this Sabrina Grinnell is the executive director of the Treasury for P&M Resources, correct?
Yeah, I forget her title. She was assistant treasurer, but I think you're right, the executive director.
And she at that time reported to Elizabeth Eden, who at that time reported to you, correct?
Correct.
And one of the things that one of the issues, that P&M became concerned about pursuant to specifically the procedural order in this case and attachment A, was the impact of bonds and the delay in bonds. Is that right?
I'm looking at the email. I mean, Sabrina or Lisa would be better to assess, what they were trying to look at and why they were looking at it. Again, I wasn't aware of this email. I wasn't aware of what they specifically were doing. So I think the email speaks for itself. So.
And what it says is that it is difficult to assess where an issuance would be priced in today's volatile markets to determine the price of a bond issuance in the future. Is that correct?
Same objection. Ms. Nanasi is testifying about the contents of this document.
Overruled.
Is that what it says on
It says, and if you go back to what I originally said, I mean, it depends on the day and the time. And this was back Friday, April 8th. And it appears that, that this individual is saying that the market is volatile and at this point in time. And again, I would encourage you to ask Mr. Atkins because he has a lot of experience in this market and he could tell you the background. Every market is a little bit different in the type of bonds and where you're at on the curve. And all those components play an important role. These are AAA bonds versus, our bond rating at P&M. And so you got to look at all those different factors and what year and what tranche they are and so forth.
And just like you said, he responded to Sabrina at P&M that it's difficult to assess where an issuance, meaning a bond issuance, would be priced in today's volatile markets. Is that correct?
Objection. That mischaracterizes his testimony.
Overruled.
I think what he says is we have used the UST for rates for different closing dates. In our view, this is the best, only way of projecting what the benchmark could be at such time. And then he goes on in bullet point 2 says, we have used the same spreads for each of the closing dates, reflecting where we think the market is. I note that this is difficult to assess where the issuance would be priced in today's volatile markets, but we have based the spreads on recent Entergy, Texas, and DTE transactions updated for the current market environment.
And just for the record, I'll spell Entergy, ENTERGY, Texas, and DTE. Did I read that correctly?
Yeah, it's DTE transaction. Yeah, DTE.
Thank you so much, Mr. Terry. I wish I had more time with you, but I appreciate your testimony. If I could please move Mr. Hearing Examiner with the caveat that I promised to change SC4, which I don't know how that got unlabeled. But other than that, I request to move into evidence NEESC 2-1, 2-2, 2-3, 2-4, 2-5, 2-6, 2-7, 2-8, and SC4.
All right. Mr. Alvidrez, any objection?
Let's go through these. I do object to NESC 2-1 as it's already admitted as the WRA exhibit, WRA exhibit 4. NEESC 2-2, no objection. NEESC 2-3, no objection. NESC 2-4, no objection. NE 2-5, I do have an objection. There's no foundation laid for it. It wasn't asked about at all.
I withdraw. I will say this. I withdraw 2-5. It's already in Mr. Fetter's testimony anyway. So thank you. I withdraw that one.
Okay. NE 2-6, no objection. I think it may already be admitted, but it was already talked about. NE 2-7, no objection. I do object to any SC 2-8 as no foundation was laid for it.
What
All
about NEESC 4?
Oh, I'm sorry. No objection to SC4.
All right. Having considered the objections, NESC4 properly labeled is admitted. NEESC 2-2 is admitted. NEESC 2-3 is admitted. NEESC 2-4 is admitted. 2-5 is withdrawn. NEE 2-6 is admitted. NEE 2-7 is admitted. And NEESC 2-8 is admitted.
Thank you very much, Mr. Terry and Mr. Hearing Examiner. I pass the witness, I believe, to WRA.
All right, let's take a break and start back up at 11:15 sharp with Mr. Michael's examination of Mr. Terry. We're on break until 10:15. Thank you all. Excuse me, 11:15.
Thank you.
Pardon me.
Ms. Gonsalves?
Yes.
Jeff Albright, Jeff Albright here while we're officially off the record.
Sure.
Has there, I may have missed it, was there anything said about the timing of the transcripts for the depositions?
3-day delivery, I understand.
Or not depositions, I meant of the hearing?
Yeah. Expedited 3-day deliveries.
Okay, great. Thank you very much.
Yep, so I'll be getting those out. Actually, as soon as I can get them out, I'll get them out.
Understood, sure. Thank you.
You're welcome.
Morning, we're back from our mid-morning break. Mr. Michael, are you prepared for your examination of Mr. Terry?
Yes, Mr. Medeiros, thank you. Would you like me to proceed?
Please do. Thank you. You have 30 minutes.
I think I have 45. Is that?
Oh, I still have you down at 30. If I didn't move some time from
We were
somebody
supposed
else.
to take time from Ms. Sanchez, I believe.
Okay, so I have you then for 45.
I'll
we'll
try and
adjust.
finish in 30. Oh,
I-
okay.
Excuse me.
But
I had understood
Go
the
ahead.
45 was moved from Ms. Sanchez and added to Mr. Monroy, who then had 65 minutes. And there wasn't a change to Mr. Terry's cross-examination time, to my knowledge.
Well, that's what I reflected. That's what I had. I did change it to 65 for Monroy. I hadn't changed anything yet for, but if you want to take some from Sanchez.
I may be mistaken, Mr. Medeiros. Let me see if I can get done in 30 minutes, and if not,
All right.
we can go from there.
Okay. I'm starting you
sorry
now.
about the confusion. Good morning, Mr. Terry.
Good morning, Mr. Michaels.
So there has been some discussion in this case about the merger commitment regarding your next rate case. And it seems like in much of the discussion that the term rate freeze and rate case stay out have been used interchangeably. And I would like you to confirm, if you know, or if not, perhaps subject to check, that in the certification of stipulation in the merger case, the hearing examiner recommended as sort of, if the merger were to be approved, which he did not recommend, but if the merger were to be approved, that there be a stay out until December of 2022. Didn't use the word rate freeze. Is that consistent with your understanding?
You know, Mr. Michaels, subject to check. I don't remember off the top of my head. So.
Okay. All right. Thank you. It's at page 72 if you do decide to check. Did you watch the hearings yesterday?
I did.
Okay. In their entirety?
Yes, I did.
Okay. And you testified earlier that you've been recently promoted. And I believe you testified that your positions with PNM and PNMR prior to your promotion were Chief Financial Officer and Senior Vice President of something. What was that?
Yes, sir. I was the Senior Vice President, Chief Financial Officer of PNM Resources, and I was the Senior Vice President, Chief Financial Officer for PNM.
Okay. And your current position is Chief Operating Officer, and are there other titles as well?
It would be President of PNM Resources and Chief Operating Officer. So
President of PNMR. Okay.
Correct.
And those positions that prior to your promotion were held by Pat Vincent Colon?
One of those positions, the president was held by Pat Vincent Colon. Nobody held the chief operating officer position. So Pat
Okay.
Vincent Colon will still be the chairman and CEO. So she's still the CEO of P&M Resources.
Okay. And those are pretty high level positions within the company, right? There's a lot of responsibility associated with those.
Yes.
Okay. And I know you testified earlier that you have not read either the financing order or the Energy Transition Act. Is that still the case?
That's still the case, Mr.
Okay. But you would agree, I assume you know this much, that the ETA is a very consequential piece of legislation for P&M. Would you agree with that?
I think it's a important piece of legislation for New Mexico and for the environment as we transition to carbon free. Absolutely.
Cool. Okay. And important to P&M, right? It addresses how hundreds of millions of dollars of abandoned plant could be managed in a way that was satisfactory to at least many stakeholders and policymakers. Would you agree?
I would agree that it provides securitization at low cost to benefit customers. Yes.
Okay. And it also allows P&M to move forward in a financially acceptable way or satisfactory way. Would you agree?
I think the securitization, and again, I haven't read the ETA, and Ms. Sanchez would probably be the best, but I think the securitization, the benefit is it took, the utility was willing to forego a return, allowed the securitization to happen at low cost dollars so that, it could benefit customers from that perspective. So to retire, to move us forward in New Mexico.
Okay. Now, you testified at your deposition that you by yourself did not have the authority to either delay the bond issuance beyond the abandonment date or to require a bond issuance on or around the abandonment date. Is that right?
Yeah, I think you asked me if I had direct authority to make a unilateral decision to delay it, and the answer is no, I wouldn't have direct authority.
Okay. And the only person that does have the authority to determine the timing of that bond issuance is Ms. Colon, right? Or Ms. Vincent Colon?
Ms. Vincent Colon, being the chief executive officer, would have that ability. I think I did also testify in my deposition that my understanding is the rate case and the bonds were always connected. So,
yeah, but it was ultimately her decision to delay the bond issuance.
I think the decision was to delay the rate case, and I think all of our understanding, at least my understanding, I can't speak for everybody else's understanding, but my understanding is the rate case and the bonds were tied together.
Well, my question was, if she decided that she wanted to go ahead and issue the bonds at or around the time of abandonment, she could do that, right?
I mean, she's the CEO, so I'm assuming she could.
Okay. And despite your promotion, you still don't have that authority. Is that right?
Correct.
Okay. And could you explain briefly what the role, and I know you talked about this with Ms. Manassi a bit, could you explain briefly what the role of the Executive Policy Committee is?
The Executive Policy Committee would be your senior vice presidents, and you have to have an Executive Policy Committee, I believe, under the SEC rules, but they would look at strategy and other elements associated with the business. So,
and how do decisions get made with respect to the Executive Policy Committee? Ultimately, it's Pat Vincent Colon, right, that makes decisions after consulting with the EPC?
Yeah, I think that, there would be a discussion of topics or whatever the topic would be, but ultimately she is the CEO.
Okay. And were you involved in the discussions that resulted in the decision to delay the rate case and or delay the bond issuance?
I was involved in the discussion for the COVID, the first rate case that Mr. Monroy testified in 2020 due to COVID. Given that COVID impacts had happened, there was an EPC discussion there that it made the right sense not to file that rate case. That would have been the one in 2020 that went through, that would have gone into effect in 2021. The other rate cases were the other rate case would have came out of discussions with interveners, and I wasn't involved in those discussions with interveners for the merger. I mean, my discussion was very limited on the merger to a handful of interveners, primarily focused on reliability and some balance sheet type metrics or measures.
And just to be clear, none of the interveners ever requested PNM to delay the bond issuance, right?
They requested PNM to the rate freeze, that they requested PNM to do the rate freeze.
That wasn't my question. My question was whether they ever asked PNM to delay the bond issue.
Not that I'm aware of, no.
Okay. If it were your decision rather than Ms. Vincent-Colon's, would PNM still be planning to delay the bond issuance?
Objection calls for speculation and is also an improper hypothetical.
Well, Mr. Hearing Examiner, expert witnesses are allowed to speculate. Mr. Terry, I think, as we established, Juan is a very high level official within the company. And more than that, had the merger been approved, would have been stepping into the shoes of Ms. Vincent-Colon. I think it's entirely appropriate to understand what an advisor at his level within the company would have done or would have recommended or would be recommending.
That wasn't the question, but and he's not presented as an expert witness. He's presented as a fact witness.
Objection overruled. Overruled.
So Mr. Michaels, can you ask the question again so I make sure I understand the question?
Sure. If it were your decision rather than Ms. Vincent-Colon's, would PNM still be planning and intending to delay the bond issuance until the conclusion of its next rate case?
Yes, it would.
Okay. And it's correct, right, that you were designated to take Ms. Vincent-Colon's place within the company and her role had the merger been approved?
Correct.
Right? Okay.
Correct.
So you would have been chief executive officer and president?
Yes.
Okay. And if I recall from your deposition, to your knowledge, Evangrid never requested or suggested to PNM that it should delay issuing bonds past the date of abandonment, right?
Not that I'm aware of. I didn't participate in any of those discussions, so.
Okay. So in your deposition, you testified that PNM delayed its rate case because the company agreed to a stay out in merger case, right?
Yes, that would have been the second rate case. It would have been delayed due to the agreement to stay out in the rate case.
Understood. And that was a delay until December of this year, right?
I think the first one was
Ultimate.
Yeah, ultimately the first one was June 1st. And then I think when the hearing examiner did the modified step or whatever the right term is, it pushed it out to December 1st.
Okay. And you would agree there were a lot of commitments for the rate case stay out made by the merger applicants in that case, right?
There was a pretty long list of commitments. So.
Okay. And PNM has no plans to honor each of those commitments, right?
If the
Given
mer-
the
if the merger
merger-
if the merger closes, correct, they would honor all those commitments.
But the merger was denied, right?
The merger was denied, correct. It's
Okay.
currently at the Supreme
And
Court.
so P&M's not going to honor the commitments of that merger, or at least all the commitments of that merger, given that there's no merger, right?
It's because it's at the Supreme Court, correct. So,
Yeah. Now, for example, P&M's not providing the roughly $70 million rate credit commitment that was part of the merger agreements, right?
correct, because the merger hasn't closed.
And not providing $25 million in economic development funds for New Mexico, or 12.5 million to the Navajo Nation.
Correct, Mr.
Yeah.
Michaels, because the merger hasn't
Okay.
closed.
Okay, and I'm not going to belabor this, but you're not providing 15 million in energy efficiency upgrades to P&M customers, right?
Correct, Mr. Michaels.
Okay, okay. Are there any merger commitments other than this rate case stay out that the company is moving forward with, despite in anticipation or not in anticipation, moving forward with, even though the merger was denied?
Not that I'm aware of. It would be the rate case is what I'm familiar with.
Okay. Now, in your deposition, I asked you if part of the reason that the company is delaying the rate case is because of a perception within the company that this commission might treat P&M unfairly. Do you recall that?
I do.
That dialogue?
Yeah.
Okay. And you testified that you did not believe that was a consideration and that you had never been involved in conversations to that effect. Is that right?
Correct. I mean, from my perspective, the rate case was delayed due to the stay out provisions or the rate freezes.
Okay. And I also asked you if you were generally familiar with the press coverage in this case, indicating that P&M would provide customers a credit for San Juan costs collected between abandonment and bond issuance. Do you recall that discussion?
I do recall that line of questioning.
Okay. And you said that you were generally familiar with those articles, and you were clear in your deposition that if P&M is allowed to go through with its plans to delay the bond issuance and delay the rate credit for 18 months, the dollars P&M collects during that period are not going to be returned in any way to customers, right?
Yeah, and I think I went on, yes, and I think I went on to explain the concept of the rate case, and the additional investments that we've made, in how a rate case overall works, as a snapshot in time. And, it's really our rates just and reasonable when you look at the whole picture, and the customers are receiving.
We understand.
Okay.
Yeah, Mr. Monroy talked about that a lot.
He did talk a lot about
It's on
that.
the record. Now, I believe you agreed in your deposition that although it's your intention to file a rate case in December of this year, it's not absolutely certain that P&M would file a rate case at the end of 2022, right?
I think so. I think I said our plan is to file a rate case in December of 2022.
Okay. But hypothetically, P&M's rate case could be delayed by years, 5 years, even more, right? That's.
I mean, hypothetical is a hypothetical. So, I mean, I would point out that, as Mr. Monroy talked, there's an earnings test and in what we're allowed to earn, and all those factors, I'm assuming, would be looked at. So, I mean, you can't just, you just can't.
And if a rate case
I'm
is.
sorry, please start your question again.
Certainly. And if a rate case is delayed beyond December of this year, and perhaps well beyond December of this year, it's the company's intention that the bond issuance would be similarly delayed, right, until the conclusion of whenever that next rate case occurs.
Yeah, no, I think I agree with you. I think the connection is the rate case and the bonds are connected together.
And I believe in your deposition, you testified that regardless of the outcome of this case, Pnm's intention to file its next rate case in December would probably be preserved regardless, right? It would, that's the company's plan regardless of what happens in this case.
You know, I think with the discussion, it takes 4 to 5 months to prepare a rate case. And so, you know, we are living to that merger commitment of December 1st. And even though, you know, the merger was denied, it's at the Supreme Court. So I think, you know, when you kind of run the clock and the time, it probably would be December 1st.
So in all likelihood, the next rate case is going to be in December, irregardless of what happens here.
I believe so.
Okay. You know, Mr. Terry, that's all the questions I have. I really appreciate your testimony. Thank you for being here.
Thank you, Mr. Michaels.
Thank you, Mr. Michael. Ms. Gould, we have you in area down for 30 minutes.
Yes,
So,
Mr.
Mr. Terry.
Medeiros, would it be acceptable if I move my 30 minutes to Mr. Setledge?
And not have any examination for Mr. Terry?
That's correct.
Yes.
Thank you.
Mr. Terry thanks you as well.
I do. Thank you.
All right. Ms. Chappelle, you're next. You have 10 minutes with Mr. Terry. Ms. Chappelle?
Your Honor, I'm sorry, my video's on, yay. I don't have any questions, and I appreciate you, Mr. Terry, for being here and answering those questions. Thank you.
Thank you.
Thank you. Mr. Albright, 15 minutes.
Yes, Mr. Hearing Examiner. I just have a few questions. Some have already been answered. So good morning, Mr. Terry.
Good morning, Mr. Albright.
I'm with J. Albright Law LLC representing Bernalillo County in the case. So a follow up on a few questions. Been discussed about the various rate cases. Do you recall that during the last rate case was case number 1600276 UT? Do you recall that?
I would recall if you termed it the 2016 rate case with rates into effect in 2018, subject to check. I mean, if that's what it is, I do recall that rate case.
And do you recall that there was projections at that time that the next rate case would be in March of 2020?
I don't recall that the timetable when the next rate case would have been. So,
do you recall that Miss Chan, Stella Chan, was provided some testimony to that effect, or same answer?
Yeah, I don't remember.
Okay, fair enough. So, couple of follow-up questions to what Mr. Michael asked you. With regard to the merger and the rate freeze, although it was suggested by the hearing examiner in his RD that there be a rate freeze, the rate freeze was never part of the formal stipulation, correct? That was presented to the commission?
I thought that there was a document that was submitted to the commission and it was under the hearing examiner recommended denial, but left a document that had been updated that included the 6 months. That for some reason, if the commission decided to approve it, that's what I remember. The hearing examiner's here, so I'm sure he'll tell me if I'm wrong.
That's if the merger were approved.
If the merger were approved, correct.
And the merger was not approved.
The merger was not approved.
And do you also recall that such things as system reliability and performance standards also was not part of the formal stipulation and was suggested to staff after the hearing ended?
I believe that there was I do believe that there was an addition for system reliability. Correct. That was included in that.
But again, that was not part of the formal stipulation that was part of the RD, correct?
I don't know. I remember a document being out there, whether it was part of the RD or filed as part of the RD.
Okay. So in looking at the timing of the bond issuance with the rate rate case, those timelines that are associated with those are very different with regard to the securitization and with regard to a rate case, correct?
I'm not following your question.
Okay, how long from the time that you file for securitization would it take to issue the bonds in general?
I would defer to Mr. Atkins, who has experience. I've never issued securitization bonds.
Okay. If the bond climate had better projections in the near term, would it be better to go with securitization sooner than a rate case if the rate case ends up being later?
You know, I defer to Mr. Atkins on the timing of what the bond market looks like and interest rates and so forth associated with that. He has much more experience in securitization bonds than I do.
If the bond rating were better, would it be to the advantage for consumers to do the securitization sooner than the rate case?
I think you'd have to look at the holistic picture of the benefits that they're receiving from not filing the rate case. So I think it's, you know, I've always viewed it as a package deal.
Okay, those are all the questions that I have for Mr. Terry, Mr. Hearing Examiner. So Mr. Terry, thank you very much. Appreciate it.
Thank you, Mr.
Time and
Albright.
your comments. Thank you.
Thank you, Mr. Albright. Mr. Borman, 15 minutes with Mr. Terry.
Thank you. I just have a few moments. I guess it's good morning, Mr. Terry.
Good morning, Mr. Borman.
Now, first of all, congratulations on your recent promotion.
Thank you.
Prior to that promotion, you were Senior Vice President and Chief Financial Officer of P&M. Is that correct?
Yes, sir.
Okay. When did you assume that position?
It would have been January of 2020.
January of 2020. Okay. Now, is it correct that the Energy Transition Act was passed in 2019?
Subject to check. I mean, that would be my guess, Mr. Borman.
Okay, fair enough. And the financing order and the recommended decision regarding the financing order were issued in early 2020. Is that correct?
Subject to change. I don't know when it was issued.
Subject to check, I presume you mean.
Change, check. Yeah, I'm sorry, Mr.
Okay.
Borman.
Okay.
Check.
Fair. I just want to be clear on the record. That's all. So, and yet you say that you, as CFO of the company, had not read the Energy Transition Act or the financing order or the RD?
Correct. I mean, I have folks in regulatory and Mr. Monroy and legal counsel that, you know, explain, but I've never read any of those documents. So.
Okay. Thank you. I have no further questions.
Thank you, Mr. Borman.
Thank you, Mr. Borman. Let's see. Mr. Schanauer?
Yes, thank you. I have a few questions. Good morning, Mr. Terry. Thanks
Good morning.
for being here. I'm just confused. I'm hoping you can clarify this. There's been a lot of discussion today and maybe throughout this hearing that involved the use of the company names interchangeably of PNMR and PNM. And I'm not clear about who, you know, which organization is being referred to when a lot of these questions are posed and answers are given. So could you help me out with that? For example, let's start with Pat Kalan. What is her position with PNMR?
For PNMR, Ms. Kalan is the chairman and CEO.
And what about PNM?
PNM, I believe currently she is the chairman, CEO, and president, I think.
Okay. And your position, okay, go ahead.
My position with PNM Resources is president and chief operating officer.
And do you have a position with PNM?
You know, PNM would be, right now would be the PNM Resources, or PNM CFO. I don't think that's been changed yet, so.
Okay. And there's been a reference to an executive policy committee.
The executive policy committee would be at the PNM Resources level, and it would consist of, I think now seven senior officers.
And those would all be officers of PNMR?
Yeah, I think they're officers of PNM Resources.
Okay. Does PNM have an executive policy committee?
It would be the similar same officers that would flow into each of the subs, TNMP and PNM and PNM Resources.
Sorry, would flow into each of the sub.
No, sorry, the same officers that would flow into PNM and similar to the TNMP side of the business, which is the Texas, New Mexico operations.
So there is an executive policy committee for PNM?
I think it's the same. It would be the same group.
And is there any significance that the commission should give to the, I guess, distinction that exists between PNMR, the corporate distinction that exists between PNMR and PNM? It sounds like the leadership is essentially the same. Is that your?
Yeah, the leadership would be the same, Mr. Hearing Examiner.
Okay. So does PNMR make the decisions for PNM?
Well, they'd be PNM officers, so they would make decisions for PNM. They're PNM officers as well too, and then they serve as PNM Resources officers.
Do they have separate meetings to make decisions on behalf of each company?
I don't believe so, no.
Okay, that's all I have. Again, thank you. Thank you for being here.
Thank you, Mr. Hearing Examiner.
Thank you, Mr. Stenauer. Mr. Terry, can you look at Mr. Atkins' direct testimony, please?
Yes, sir. Let me grab it.
Thank you. I just wanted you to confirm something he said there first, that he says in his experience on page 5.
Is this of his direct testimony? Okay.
Yes, sir. Sorry. He thinks it would not be reasonable to engage rating agencies in connection with a securitization transaction more than 3 or 4 months prior to the planned issuance.
Yeah, I see that.
Are you familiar with discussions around engaging the experts that you need to engage for leading up to the planned issuance, the steps you need to take?
Just what I've read in Mr. Atkins' testimony. So
in March 2021, had the company, whether it's PNMR or PNM or the EPC, had any discussions around initiating that process?
Not that I remember, Mr. Hearing Examiner.
But that's already almost 3 to 4 months out before the July 2020, the issuance, right? No, wait, we're talking about 2022. So that would be way too early to have those discussions. So I guess my question is, had PNM ever started the, in 2022, ever started that process before deciding to delay the bond issuance?
Not that I'm aware of, Mr. Hearing Examiner.
Never started those discussions?
No.
Okay. Are you familiar with the Four Corners proposed abandonment in the Four Corners application in case number 21-00017-UT at all?
No, only at the very,
I'm
very,
sorry.
sorry.
Please repeat that number again.
21-00017-UT, and I'm sorry for saying it so fast. You're not really familiar with it?
No.
Never had any discussions around the abandonment and proposed securitization of Four Corners Power Plant?
At the 50,000 foot level, Mr. Hearing Examiner.
You recall I asked Mr. Monroy about that case, right?
I do.
And I asked him, why wasn't there a similar link up or syncing of the securitization and the conclusion of a rate case around or related to the Four Corners abandonment, right?
I think I remember you saying that, Mr. Hearing Examiner.
Why wouldn't you, the company, have a similar connection or linkage between a rate case disposition or conclusion and the securitization with respect to the Four Corners Power Plant that you all repeatedly emphasize with regard to syncing up the similar arrangement with regard to the San Juan generating station?
You know, I don't know. I have not played that much of a role in the Four Corners, Mr. Hearing Examiner.
Well, the Four Corners bond issuance was presented to the commission at a hearing in the fall of 2021. You accept that, subject to check?
Yes, subject to.
So as late as the fall of 2021, and then in the recommended decisions that I presented to the commission, because we both are dealing with the abandonment and securitization and also coverage of non-securitized costs of the abandonment for Four Corners. There never was really that emphasis or linkage presented to the commission that there was around the San Juan generating station. Would you accept that?
Yeah, I mean, I'm not aware of anything different, so.
Okay. We asked those questions ahead of PNM presenting its examination or having its examination of you. We wanted Mr. Alvidrez to hear our questions as well before presenting his examination of you. So Mr. Alvidrez, go ahead.
Yes, thank you, Mr. Hearing Examiner. Mr. Terry, do you recall whether there was a regulatory commitment involving PNM appointing a chief environmental officer?
There was, yes.
Has PNM appointed a chief environmental officer since the merger case?
Yes, they have.
I also wanted to follow up on some of the questions that Mr. Shanauer had asked you with regard to PNMR and PNM. What is the relationship between those two corporations?
PNM Resources would be the parent and PNM would be the subsidiary.
And who owns the stock in PNM?
PNM Resources.
And are they separate corporations?
I believe they're separate registered corporations, correct.
And do they have separate boards of directors?
They do.
Is there some overlap in terms of the makeup of the boards of directors between PNM Resources and PNM?
There would be.
And you indicated that you thought there may be I guess an executive planning council or executive planning committee, an EPC relative to P&M. Are you sure about that?
Objection. That is not what we referred to. There was no executive policy committee.
Overruled.
Sorry. Executive Policy Committee.
I think to clarify, it's the exact same executive policy committee. I'm sorry if I wasn't clear. It's the exact same executive policy committee for both P&M Resources and P&M.
Well, I mean, my question was, does P&M have an executive policy committee?
The answer would be no. I interpret it as being the same people.
Okay. So in terms of the relationship between PNMR and P&M, how is policy set?
Policy at P&M would be set by that executive policy committee. So policy would be set by that executive policy committee.
Would it be set at the P&M level or at the PNMR level?
It would be set at the P&M level, but it's the same individuals. The PNMR.
All right. Thank you very much. Those are my questions.
Thank you, Mr. Alvidrez.
I just have one very quick clarifying question, if I might, based on a question that Mr. Schanauer asked.
Go ahead.
Mr. Terry, I believe you testified that there were 7 members of the Executive Policy Committee. And Mr. Monroy yesterday testified, I believe, that there were 6. Ms. Vincent Colon, Mr. Darnell, yourself, Mr. Eldred, Mr. Apodaca, and Mr. Olson. Is there another member?
Yes, it'd be Miss Eden was
Ms.
added.
Eden.
Yes.
Okay. Thank you.
Thank you.
All right, if there's nothing else for Mr. Terry, thank you very much for testifying before the commission. We appreciate your participation in this hearing, sir.
Thank you, Mr. Hearing Examiners.
Thank you. You're excused. All right. We could start now with Mr. Atkins, but I think that we did have a short break, but I think that subject to hearing examiner Schanauer's view of it, I think we should break for an hour and start with Mr. Atkins at 1. Mr. Schanauer, are you good with that?
That's fine with me.
Okay, so
Can I ask you a question?
yes, ma'am.
Sorry I didn't mean to interrupt. Could you tell me what the
Order?
Schedule is going to be after that, after Mr. Atkins, because he doesn't have a long time, I don't think.
I believe I had it on screen. Let me pull it back up. The order, the revised schedule of witnesses. I have Ms. Sanchez after that.
Okay.
After Mr. Atkins.
And so,
and I think that's all we're going to be able to do today, because we have witnesses slated for tomorrow that I guess we could have Ms. Porter possibly available if there's time. We'll see. And yes, sir, Mr. Marks.
Thank you, Mr. Medeiros. And I didn't mean to interrupt you, but I don't have any questions for Mr. Atkins or Ms. Sanchez, although I would concur with you that she is quite experienced an attorney. But I would ask that I be excused for the afternoon then.
Yes, sir.
Subject to roll.
You are excused. Yes, sir.
Thank you.
Mr. Michael?
Yes, Mr. Medeiros, just wanted to let you know that Ms. Beatles will be appearing for WRA this afternoon and probably for the remainder of the hearing.
Okay, thank you, Mr. Michael. I'll be looking to admit her to the Zoom conference after the lunch break. So Mr. Marks is excused this afternoon, and we have, Mr. Atkins at 1 Mountain Time, 3 p.m. Eastern Time, I believe. And then we'll have Ms. Sanchez after that. And possibly, if somebody could alert Ms. Porter that she's on standby.
And Mr.
Yes,
Harry,
sir.
this is Rick Alvidrez. With regard to Ms. Porter, I see we're the only party that has reserved any time for her, and it's 5 minutes. We'd be willing to stipulate her testimony in and waive cross and save her having to sign in.
All right, is that acceptable to the parties? Is there any objection to stipulating the admission of Ms. Porter's testimony? Hearing Examiner Schanauer, did you have any questions for her? I should ask first.
No, I don't. I'm fine with that.
Okay, so and Ms. Porter's testimony is labeled what in Dropbox? Let's look at that.
I think it's 2.
CCAE SC-2.
Say it
So,
again. Sorry, say it one more time.
Sure. CCAE SC-2 is the ONA Porter response testimony. So is there any objection to stipulating the admission of CCAE SC-2 and waiving her examination at this hearing?
Objection.
Hearing none.
Your Honor, this is Kara Lynch, representative for Prosperity Works witness, Ona Porter.
Okay.
Is it
Yes,
appropriate now for me to assert that, Prosperity Works would at least like to make a statement predicting that there would be no cross-examination of Mrs. Porter despite the importance of her testimony?
That the relative weight of her testimony remains to be determined by the hearing examiners and the commission, but I don't see any cross-examination of her requested. Is there anybody speak up now? There wasn't any before. The only party was Pnm, and that Pnm, as I understand, Mr. Alvidrez has just waived cross-examination of Ms. Porter. And so without objection, then Ms. Porter's testimony, which is labeled CCAE SC-2, is admitted, and she's excused from testifying at this hearing.
You see no merit in her ability to make a statement on her testimony?
I was hoping that you would avoid that because we've gone over in great detail the fact that we discourage oral examination in lieu of pre-file testimony. So I don't understand the necessity of requiring, she stands on her pre-file testimony, and that's normal commission practice.
Okay, thank you, hearing examiner.
You're welcome. Again, oral direct examination, we just went through the process of the exception to the rule with Mr. Terry. Outside of extreme exception to the rule, which we applied in with regard to Mr. Terry, witnesses present pre-filed written direct testimony, which is then subject to cross-examination and examination by the hearing examiners and any commissioners. Outside of exceptions to that, the normal process, witnesses typically do not provide oral narratives in commission proceedings, adjudicative proceedings at least. So with that, let's take our unless there's anything else to address, let's take our lunch break and see Mr. Atkins in an hour from now. Thank you all. Have a good lunch break. Good afternoon, all. We're back from our lunch break on the second day of hearings on the show cause motion in 19-00018-UT. Mr. Alvidrez,
Yes, Mr. Hearing Examiner, we're ready to call our next witness, and we would call Charles Atkins. And I see Mr. Atkins is online and hopefully unmuted. And so.
and ready to be sworn.
Right.
I'm here. Can people hear me?
Yes, sir.
Good, good. Excellent, excellent. Thank you.
Raise your right hand for me, sir, and I'll swear you in. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, I do.
Thank you.
Good afternoon, Mr. Atkins. Can you please state your name and place of employment for the record?
Yes, I am Charles N. Atkins II, A-T-K-I-N-S, and with Atkins Capital Strategies, LLC.
And Mr. Atkins, did you prepare pre-filed written testimony in connection with this case?
I did, yes.
Okay, and we have marked as P&M Exhibit SC3 your direct testimony in response to April 1, 2022 procedural order as an exhibit. And let me ask you, do you have any changes or corrections to make to that testimony?
I do not, sir.
And if you were asked the questions that appear in that testimony today, would your answers be the same?
Absolutely, yes.
And is this testimony true and correct to the best of your knowledge and belief?
Yes, it is.
We would move the admission of P&M Exhibit SC3, the direct testimony of Mr. Atkins.
Is there any objection? Hearing none, P&M SC-3 is admitted.
Okay, turning to your rebuttal testimony, we've marked that as P&M Exhibit SC4. Can you tell us, do you have any changes or corrections to make to P&M Exhibit SC4?
I do not know.
And if you were asked the questions that appear in that testimony today, would your answers be the same?
Yes.
And is your rebuttal testimony true and correct to the best of your knowledge and belief?
Yes, it is.
Okay. I would move the admission of P&M Exhibit SC4, the rebuttal testimony of Mr. Atkins.
Any objection? P&M SC4 is admitted as well.
And with that, we would pass Mr. Atkins for examination.
Thank you, Mr. Alvidrez. Up first with Mr. Atkins is Western Resource Advocate. Good afternoon, Ms. Beatles.
Good afternoon, hearing examiners and colleagues. And Mr. Atkins, good afternoon to you too.
Hello, good afternoon. Good afternoon. It is a cloudy day here in Manhattan.
Well, fortunately, it's slightly overcast here in New Mexico because we've been suffering from one of the biggest wildfires in the state ever.
I know. It's catastrophic, and all of us have to actually work on that. Yes.
I agree. And I don't know if you recall, Mr. Atkins, but I met you on the phone. I think it was in early 2020. I'm wondering if that was it, maybe 2019. I was with Western Resource Advocates already, and Doug Howe, our expert witness in the case, wanted to talk to you about how utility securitization transactions work. Do you recall that?
I do, yes.
Okay, so I have some questions for you. I'm sorry.
Good to see you on screen.
Right.
And Ms. Beatles, for Mr. Atkins, I have Western Resource Advocates down for 5 minutes.
5 minutes?
That's correct.
How did that happen?
Because Mr. Michael needed more time, I believe, with Mr. Monroy.
I think he took that from Ms. Sanchez. Yes, that was what I suggested he do, not Mr.
Okay.
Atkins.
So let me look at the previous list because I may have taken it away from the wrong witness. The pre-hearing order, let me pull that up. That had you originally scheduled for 20 minutes. That's right, 20 minutes with Mr. Atkins. So you have 20 minutes. Go ahead, 20 minutes.
Thank you, Mr. Hearing Examiner. I trusted that you're trying to move me along. And
No, not that fast.
okay. And I may need more than 20 minutes with Mr. Atkins, and I would take that from, I would ask that be taken from Ms. Sanchez, but maybe can we cross that bridge when I get there?
Yes, ma'am.
Okay. Mr. Atkins, did your counsel advise you yesterday or earlier today that I may be asking you a few questions about your original testimony in this docket?
Yes.
All right.
Thank you.
You may or may not need to refer to it, and I will give you page numbers in case you do.
Okay.
Wait, can I interrupt just a little bit? Mr. Atkins, I'm having a little bit of trouble hearing you. I don't know if you can get closer to your microphone or speak up. It's a little echoing. I want to get your test.
Oh, I think I'm in a dining room, and so I can't really.
That's okay. I'm hearing you now. If you can speak up or I'll interrupt you. I want to get your testimony, okay?
All right, you hear me now?
Yes.
Good. Good. Hold on. Let me adjust my sound here. It might increase. You know what? I think I'm good.
Did you get that, Ms. Gonzalez?
Well, I didn't hear what he just said.
I think that we can go ahead. Can we go ahead?
Okay. So in your direct testimony filed earlier in this case on July 1st, 2019, you testified that it was important for the financing order to have built-in flexibility to improve the marketability of the bonds. Is that correct?
I think that sounds accurate, yes.
And one example you provided on page 17 of your rebuttal testimony filed on November 15th, 2019, to repeat in that rebuttal, one example you provided was the use of one or more credit enhancements in case market conditions change. Is that correct?
I am tuning to that page, but that sounds correct. On page 17, you said?
Yes, of your rebuttal.
Yes.
Would you agree that the flexibility in the final terms and conditions that utilities should be provided in financing orders relate to the pricing, marketing, and structuring of the bonds?
I would say that it also includes market timing and it also includes other factors. And so I would not limit it. I would include all those factors, but I would not limit it to those factors.
Your earlier testimony in this case, on page 46 of your 2019 direct, your earlier testimony in this case was that the financing order that was granted to P&M recognized the need for and afforded the company the flexibility to establish the final terms and conditions of the bonds. Is that accurate?
I assume so. Yes, and I would also, well, I think that we can get to the order itself.
The order itself, okay, the financing order, please turn to page 150.
And for the record, are we talking about the recommended decision?
Yes, thank you, Mr. Alvidrez. Page 150 of the recommended decision.
Yep. I'm there.
I'm not, just a second, let me get there. So if you refer down to the last 3 sentences of page 150 and the first 2 of the next page, it does say, does it not, that subject to compliance with the requirements of this financing order, PNM and the SPE, special purpose entity I'm adding, back to the exact language of the financing order, shall be afforded flexibility in establishing the terms and conditions of the energy transition bonds, repayment schedules, term, payment dates, collateral, redemption provisions, credit enhancement, required debt service, reserves, interest rates, and other financing costs. Do you see that, Mr. Atkins?
I do see that, and I would say that when I read the order, I read the order within the context of the ETA as well as the consolidated application. The ETA itself has 8 or 9 instances where it specifies a date certain. It does not specify a date certain with respect to issuance of bonds. And in at least 4 instances, it specifies that an application must include estimates. And so, including an estimate about the amount of energy transaction cost, the estimate about the transaction cost, ongoing costs. And
So the transaction costs and?
yes, the transaction cost, as well as estimates about the timing and the scheduled maturity. And so that leads to the consolidated application, because the all of the findings of fact in the order and the conclusions of law tie back, well, as I read it, I did not write it, but as I read it, all tie back to the consolidated application. And so when I take a look at the order, I take into account the consolidated application as well as the supporting testimony.
Mr. Atkins, have you reviewed the consolidated application?
Yes, I have.
So you're aware, aren't you, that the page 8 of that application states that the bonds are to be issued at or around the time the San Juan coal plant is closed, right?
I look at page 34, which is.
But I asked you about page 8, and I want to know if you are aware of that.
I'll take a look at page 8. I don't have that full consolidated. I don't have that complete consolidated application already printed out. I do have it, but I don't have it printed out. So I will take your a word for it, subject to a check.
Right, and on page 21, the consolidated application also states that the bonds are to be issued around the time the San Juan coal plant is abandoned. Would you accept that, subject to check?
Yes, and so I think that we're inching closer to the part of the consolidated application.
And
where-
both of those statements provide the estimate of the timing that PNM is providing as to when it'll issue those bonds. And that estimate is required by the ETA, right?
I would say that the estimate, which happens to be a qualified estimate, is contained in the particular section of the consolidated application, which begins on page 34. And if you turn to page 34, and if you turn to paragraph 54, it outlines the qualified estimate of the issuance timing.
I'm sorry, of the what?
Issuance timing. And so it does outline those 4 conditions, which other witnesses have also talked about, which is a part of the evening testimony. And then
I haven't asked you about those 4 events. I mean, I'm required to allow you to explain your response, but I haven't asked you about those. I'm just asking you about the flexibility that the financing order affords PNM, and like any utility, the purpose of that flexibility. So I'd like to return to that.
Well, Mr. Examiner, please let the witness finish his answer. He was describing paragraph 54, which is under the proposed timing of issuance and term of the energy transition bonds.
Well,
Yes,
I'll stipulate. Go ahead.
We're familiar with the application and those provisions. Let's move on.
Well, excuse me, Mr. Hearing Examiner, I do want to state that as a part of paragraph 54, there is a specific qualification to the timing estimate, and that the rest of the order refers back to the consolidated application, which contains a clear qualification that it states the company currently estimates the issuance of the energy transition bonds would occur in 2022. So it is.
I understand.
Mr. Atkins?
And Mr. Atkins, I'm pausing for a second. And Mr. Atkins, were you watching the hearing yesterday afternoon when I questioned Mr. Monroy around these issues?
I did not hear that apart. I was away. I did hear everything up to about 3 o'clock Mountain Time.
Okay. Ms. Beatles, go ahead. I paused your cross-examination. I will. Are you finished with your answer, Mr. Atkins? I understand what you're saying, but I want to get back to Ms. Beatles' cross-examination.
Sure.
Ms. Beatles, are you ready?
Yes.
Okay, please resume.
So, Mr. Atkins, you recently filed testimony in a case where Duke Energy got a financing order from the North Carolina Utilities Commission. Is that right?
I did, yes.
Yes, and you also filed or gave testimony in Entergy Texas's application for a financing order, right? That wasn't recent, but I would say around 2009.
I think that was a long time ago, but yes.
Okay. So, and those financing orders provided similar flexibility, establishing the final terms and conditions. Is that correct with respect to the structuring, pricing, and marketing of the bonds, right?
Yes, yes.
And the point of that flexibility is to let me say this. I mean, the point of that flexibility is to gauge the market conditions in order to achieve the lowest cost objective for ratepayers, right?
It is to adjust the particular structure and the overall marketing plan and the overall timing of the initiation of marketing in order to try to achieve the lowest cost in, well, whatever market conditions. And so you have to take into account a lot of different factors there.
And that's to, you know, and that's to, for purposes of taking into consideration the prevailing market conditions at the time of issuance, right?
Yes, and there are a lot of factors that go into market conditions.
Okay, so let's turn to your direct testimony in this show cause case. And on page 16, you discuss the importance of regulatory stability for the marketability of utility securitization bonds. Is that correct?
It is one of the particular factors that the rating agencies take into consideration. Yes.
And you state that that is important, right?
The agencies state that it is important. The agencies state that the overall legislative and the overall regulatory the framework are important.
Would you agree that regulatory stability is a two-way street? That it is also important for utilities to execute securitization bond issuances in a manner that conforms to its financing order?
I would say that any issue needs to have a legal opinion that it complies with the order.
Thank you. And if the commission finds that Pnm's plan to delay bond issuance until the conclusion of its next rate case does not substantially conform to the financing order, could the credit profile and rating of its bonds be adversely affected?
Any issuance would need to have a legal opinion that it complies with the particular financing order which is governing that issue.
Mm-hmm. Okay, let's go now to page 5 of your direct testimony.
About 4.5 minutes, Ms. Beatles.
I think I need, if you don't mind, to take another 10 from Ms. Sanchez, leaving me 15 minutes with her.
Okay, I'm resetting you for 15 minutes.
Thank you. let me follow up on what you just said, Mr. Atkins. You said that issuances involve a legal opinion. Issuances of bonds would necessarily involve a legal opinion as to its compliance with the financing order and the statute, right?
Yes.
And if that legal opinion concludes that or results in finding that the issuance does not conform to the financing order authorizing the issuance, couldn't that adversely affect the credit profile and rating of the bonds?
It would not, because the bonds would not be issued.
All right, thank you. So on page 5 of your direct testimony, you state that you would not expect PNM to have begun the execution of its bond issuance since it takes only three to 4 months, based on your understanding that PNM does not propose to issue bonds within 3 or 4 months. Is that right?
Yes, I said that this is, yes, and this particular time frame assumes that, I think that this particular time frame only deals with when you engage rating agencies. It does not.
I'm sorry, only deals with?
Only deals with when you should engage rating agencies. It does not deal with a complete timeline for the transaction.
So, sir, if the commission finds that the financing order authorizes the issuance of bonds at or around abandonment, and the commission further finds that PNM's plan to delay bonds until after its next rate case is outside the scope of that authorization, if PNM wants to recover its stranded costs with securitization bonds, it should probably start engaging rating agencies now, don't you think?
You know, as I do read the order, there are also numerous findings that there was an intention to file a rate case that would also go into effect at the same time as the energy transition charge. And so it's difficult for me to respond to your question.
Well, Mr. Atkins, utilities can file a rate case whenever they want. So, and they haven't, and PNM has not filed that rate case. So in the meantime, if it wants to recover its stranded cost via the issuance of the bonds, and if the commission says they were authorized to issue bonds at or around abandonment, shouldn't they start engaging rating agencies now?
I cannot speak to, a rate case timing, and I think that this is a question that deals with the timing of a rate case.
Well, you understand that rate case timing may have been part of PNM's financial plan as a corporation, but it wasn't a condition of the bond issuance authorization. You understand that, right?
I do not understand that because when I read the recommended decision, I read that the rate case and the implementation of the energy transition charges, which can only exist after a bond issuance, were actually tied together. And so that is in the order, and it is in the supporting testimony.
Did you read the financing order where it set a rate credit if P&M had not filed a rate case by then?
I haven't. I'm not sure about how the particular rate credit and the regulatory, any particular regulatory liability would actually function. Yeah.
So, are there any, to change the topic, are there any hedging opportunities or financial instruments available to a utility?
I would say that.
Wait, let me finish my question. I'm sorry. That in case the regulators or P&M would want to mitigate the risk of future increases, are there any instruments that would be available in order to hold ratepayers harmless?
Are you talking about interest rate hedges?
Yes. Are they available in the context of utility securitization bonds?
In my almost 25 years of experience, I did not recall any interest rate hedging, because hedging does involve cost and it is speculative. And so, you don't have a variable rate, you don't have interest rate swaps, and you don't do hedging. So I am not aware of any hedging.
Mm-hmm. And you also recommended that P&M's bond issuance not be divided into two smaller issuances, right?
I would say that you have to take into account there is a deluge of utility securitizations that are taking place this year. It is about 14 to kind of 15 issues, whereas in 2021 there were only 5 transactions. In 2020 there were 0 transactions. So we have about 23 billion of utility securitizations that are taking place, and you have 7 or 8 of those transactions are well in excess of a size of 1 billion. You just had one that was about 3.6 billion, and which was for PG&E. And then there was one for about 3.1 or 3.2 billion. That was for Entergy Louisiana, which occurred this month. And so as it is larger transactions tend to attract a lot more investors. And so typically smaller transactions have what you might call a illiquidity premium, which means that they have a relative disadvantage and could have a higher cost. And so it is a factor that you have to take into account.
I mean, wouldn't the liquidity of bonds issued pursuant to a smaller P&M transaction be considered in the context of a secondary market that also includes all these bonds issued by all the utilities you just listed?
Well, yes, I think the secondary market activity is always taken into account, but investors have a lot of choices about bonds which they can buy. And investors do have a choice about how much time.
So they do have a what about how much time?
How much investors have a choice about how much time they're going to allocate to analyzing any particular bond issue. And so a smaller transaction, it just means that you have that after you spend time analyzing it and after you spend time trying to take it through an internal credit committee, that you have actually less of a chance of getting an allocation of bonds that you want because there's not as many bonds there. And so there's a tendency to try to choose larger issues where you have.
I'm sorry, there's a tendency to what? Please, I'm sorry.
Oh, sure. There is a tendency to try to spend your time on larger issues where you have more of a chance to get a certain amount of bonds. And so I think that is one of the particular reasons why a smaller issue has a disadvantage. Another disadvantage is a secondary market disadvantage in that a smaller transaction ends up with having a smaller number of bond holders. And so in a secondary market, there are not as many opportunities for an investor who is holding bonds to be able to try to sell bonds to another person. And so those are factors which have to be considered.
So the fact that all these other utilities are issuing bonds this year suggests that they're not trying to time the market, right?
I think that they are issuing bonds. It is a choppy market, but it is a functioning market.
I have no further questions. Thank you.
You're welcome. Thank you. Okay. Next up is with Mr. Atkins, CCAE and Prosperity Works. Ms. Lynch, you have 45 minutes slated.
Co-counsel Ms. Zur will take this.
I'm sorry. Okay, Ms. Zur, 45 minutes.
Yes, sir. I will not expect to use that much time.
That's fine, but I'm setting the clock for that amount, so go ahead.
Good afternoon, Mr. Atkins. I'm Stephanie Zur with Coalition for Clean Affordable Energy. How are you?
I'm doing fine, thanks.
Okay. Would you please go to CCAE SC 25 and open that exhibit, please?
I think I have it already printed. Let's see here. Here's 10 and here's 25. Yeah.
And could you read for me the question under your name there, NEE 73 Charles Atkins. Could you please read me the question if you have that in your hand?
Yes, it says, please provide the most recent calculations that PNM has regarding the total cost to the ratepayers on the energy transition bonds based on the amounts requested in PNM's application, including any return on investment or fees to PNM or its bond issuer if there is,
Or its bond, I'm sorry, or its bond what?
or its bond issuer if there is a difference based on 25-year recovery versus 28-year recovery. And then please provide data for both eventualities.
And you provide an answer below, and you refer to your answer as providing an aggregate amount. What does that mean? What are the aggregate amounts you're providing?
It includes the aggregate amount of the interest and principal bond payments and the ongoing financing costs over a 25-year period. A scheduled maturity of up to 25 years.
Is it fair to say that if bonds were issued at the time of abandonment, this is the amount ratepayers would expect to pay for San Juan related costs for that 25 to 28-year period?
No, because all of these estimates were based upon rates as of June of 2019. And
okay.
so, yes, I think that there was an estimation of at the time of my testimony, I'll say it was near the time of my testimony, and that there was no estimation of any future rates.
Okay, so first, before I forget, Mr. Hearing Examiner, may I move CCAE SC 25 into the record?
Any action to
No objection from P&M.
Are
CCA?
you-
May I admit it? CCAE SC-25 is admitted.
Mr. Atkins, for any estimates provided during the pendency of this case that you're aware of, I know you may not be aware of everything, but do you know of any estimates that provide any cost between aggregate costs between the time of abandonment and bond issuance to allow ratepayers to know the amount they would pay if there were a delay in bond issuance?
I don't know, no, I'm not aware.
Okay. In exhibits to, and I'm not going to ask you to go look at them, but you saw the testimony that was submitted in the original action, the proceedings back in 2019. Are you aware of any P&M witness providing estimates of the cost to ratepayers of a delay in the bond issuance?
I do not believe that. I understand that there was no testimony that estimated rates as of 2022.
Okay. When you talk about flexibility in the ETA bearing on the provisions in the financing order related to the estimated time of bond issuance, are you suggesting some role of statutory construction? I mean, what's the point about flexibility and other provisions in the ETA? Could you explain that to me?
Oh, well, that there is no utility and there is no investment bank or underwriting firm. There is no law firm. And there is no commission that can predict the future. And so a financing order sets forth a groundwork for one or more transactions that will take place at a future time.
So I guess my question was, is there some principle of statutory construction that you're referring to? Are you saying this is implied from the ETA, this flexibility? Is it implied? Because you've pointed me to specific provisions that don't seem to directly address this situation. That's my question.
Well, I think that it's clear in the order that certain estimates are going to be updated after issuance. And so I think it's kind of obvious.
It's an update. It's an update to their estimate. Based on the actual events described in the financing order, wouldn't an update be an update based on a different time of abandonment? Or perhaps a longer Supreme Court appeal than was anticipated?
Or a different timing of a rate case.
A different reason to change the timing then, right? That's what you're saying?
No, I didn't say that.
Okay, all right. Well, I don't want to put words in your mouth. So let me ask another question. If we were looking, strike that. Hold on a second. Does this intent to allow a utility to have flexibility, as you say the ETA suggests, can that contradict an express term of the financing order?
I would say that by express term, I would say that a mandate or the use of shall or the use of will is, I think that those words and those terms are different from an estimate and are clearly different from a qualified estimate.
Okay. Do you know what the word pole star means? Something by which we guide ourselves.
I like North Star, but yes.
I can go with North Star. Isn't the pole star for the timing of bond issuance in the financing order abandonment?
I would disagree with that because there is a significant amount of discussion in the recommended decision and in testimony that there will be basically three things were estimated to occur in 2022. That there would be a conclusion of a rate case, and then that there would be a bond,
I'm sorry, there'd be what?
a bond issuance. There was a qualified estimate that there would be a bond issuance, and then the intended rate case was to become effective approximately 30 days after bond issuance, because the start of the energy transition charge was planned to occur in conjunction with a new rates out of a rate case. And so it is in the supporting testimony and in the order. And the order itself, when it talks about the issuance timing estimate, refers back to the consolidated application, and the consolidated application, it clearly makes a qualified estimate by, it did not say that the company will issue. It did not say that the company estimates an issuance in 2022. It says that it currently estimates an issuance in 2022. And so I think that all of those are the key factors here, at least how I read the order.
I don't think I'm sorry, I thought you were finished. Go ahead.
Yes, and so I think that there are specific citations in Mr. Monroy's exhibit number 3, where the rate case and the start of the energy transition charges are tied.
Are you finished?
Yes, yes, I am. Thank you.
We will issue bonds when we file a rate case, an updated estimate or a new poll star?
I don't understand the question.
Well, we talked about what a poll star was just a minute ago. That means the event upon which other events will turn. Just like we navigate by the North Star, or we could navigate by some other star, but the poll star in the financing order is the 4 events. You're adding a 5th event, rate case now, right? How is that an update? So my question to you, is that a new poll star or is that an updated estimate? You told me that was an updated estimate.
I said that it is a qualified estimate that was in the consolidated application, and as to state that there was, in addition to a rate case occurring, a rate case being finalized and effective in 2022, there was the abandonment of the San Juan plants expected in 2022. I think some of those dates have actually changed, but they're still expected in 2022. And so tied to the rate case that was due to be effective in 2022, there was an expectation that the energy transition charges would be effective at the same time as new rates.
Can you please, do you have a copy of the financing order? Could you please turn to paragraph 28, which is on page 120?
So on page 120, okay, hold on.
Let me know when you're there.
Sure. Yes, I think that this also happens to be a particular paragraph which I highlighted.
Okay, I haven't asked you a question yet, so if you, I don't mean to be rude, but could you please wait, sir? Okay.
Apologies.
No problem. It's all right. I'm usually the one interrupting, so I'm used to it. So, okay. So paragraph 28 says, as described in the consolidated application, including supporting testimony, PNM expects to cause the issuance of energy transition bonds as promptly as possible after the last of the following events have occurred. And then it refers to what we keep calling the 4 events. Now, if you add in a 5th event, okay, bonds would be issued, let's see. Let's add a 5th event that says PNM will issue the bonds after the conclusion of a rate case. Then doesn't that make the part where it says bonds, PNM expects to cause the issuance of energy transition bonds as promptly as possible after the last of the following events have occurred, no longer true?
I would say that a key part of this particular paragraph is the introductory phrase, quote, as described in the consolidated application.
Okay. And this is the financing order, right? And so the reference to as described in the consolidated application refers to what the hearing examiner says next, the 4 conditions. The hearing examiner is not citing to PNM's intent to file a rate case here, is he? Are they?
There are other references.
I'm not asking about that.
Well, all I see here is that the hearing examiner is saying, as described in the consolidated application, including the supporting testimony.
Mm-hmm.
And in the consolidated application, there is clearly a qualified estimate. It's not just an estimate of the timing, it is a qualified estimate. And so I think.
But read the sentence after that. Okay, as described in the consolidated application, including the supporting testimony, PNM expects to cause the issuance of energy transition bonds as promptly as possible as after the last of the following events have occurred. And he doesn't say, as described in the consolidated application, PNM will issue the energy transition bonds as promptly as possible after the last of the following conditions, including a rate case. It just doesn't say that, does that? And so he's not referring to testimony in PNM's application about a rate case and a 5th condition. It's not here, is it?
It is in, there are other references.
Okay, but my question is it here in paragraph 28? Look at paragraph 28, please. I'm sorry, I don't mean, I'm going to calm down here. I'm not very good at.
It includes.
I beg your forgiveness. I'm going to be patient here. We're going to do this right. Okay. I really would like you to look at paragraph 28 and answer my question, please, about paragraph 28. That sentence there refers to the supporting testimony and described in the consolidated application as supporting these conditions and none others. This doesn't refer to a rate case, does it? Paragraph 28, that's what we're talking about. This is the hearing examiner's reference, not Pnm's, okay? Can you answer my question?
It includes the supporting testimony, and it talks about an expectation that Pnm has. It
Okay,
says,
I'm sorry, go ahead.
expects.
Okay.
That's all that I can say. I mean,
Sure, but all right, so, you know, even if we agree that there's got to be some flexibility and, you know, maybe Pnm doesn't issue the bonds at all, right? So, you know, you expect this, but maybe that doesn't happen. But I don't think you answered my question about if you add a fifth condition here that says is promptly after the conclusion of a rate case, does that not now nullify everything, all the four conditions? I mean, they have to happen first, but the part that says as promptly as possible after the last of these four, if you add a fifth, then you are going to commit to doing it as promptly as possible after these four, right?
you know, it does say four, and it does refer to the consolidated application. It does not include a rate case here, but there are other findings of fact in this order that refer to the expected timing of a rate case, also with the start of the energy transition charges. And so there are, you know, if you look at page 71, 85, 105 to 106, they all talk about an expectation that the effective rates out of the rate case would be at the same time as the energy transition charges.
I'm going to have you look at paragraph 28 one last time, and then I hope this will be my last question, okay?
Hold on, Ms. Zer. I paused your time. Okay, you'll have your question. I paused your time. I just want to reflect for the record. This, Mr. Atkins, this was partly what I was talking about with Mr. Monroy. You're really familiar with the ETA and with the financing order, obviously. But everything that you cited regarding the company's position and your position regarding the linkage, the almost inextricable linkage of the issuance of the bonds to the disposition or conclusion of the rate case, all of those references that you cite happen before the findings and conclusions of law on page 108, isn't that correct? I can go back. I have real time today, so I can tell you what you cited.
Okay.
Because I've been going along as you've been talking, and I've been looking at those things as well. Again, just to confirm. But just so we're clear, those references that you cite all happen, as you call them, findings, are findings made before page 108 of the recommended decision on financing order. Isn't that correct?
Let's see. I think that those particular, I'll say that those particular citations, yes, are that they come prior to the findings of fact, but
you accept that they do become findings of fact and conclusions of law of the commission, as set forth in the first paragraph of page 108, or incorporated by reference.
Yes, I see that on page 107, that the hearing examiners accordingly proposed with the foregoing statement of the case, the background and discussion as the initial part of
Right.
this is recommended financing order.
And what wasn't there before, because I recall adding this, was that last phrase, proposed by P&M to be consistent with the body of this recommended decision. I added that, or we added that, the hearing examiners added that. So to make clear that those, to try and make clear that the findings on page 107 and before are carried forward into effectively the financing order. You see what I mean? We were alert to this issue. And so you're confirming that by citing findings made before page 108. And again, I have them here in the transcript that's been filed already. You talk about on page 107, on something in the 70s, et cetera, et cetera. So I wanted to pause so to make clear that we're on the same page, so to speak, as far as this interpreting this financing order and what becomes a finding of fact and conclusion of law for the commission. So the bottom line is, do you agree that findings made before page 108 are actually findings of fact and conclusions of law, or can be considered that?
Yes, it does say that on page 108 at the top. Yes.
Okay. All right. Okay. Ms. Zar, back to your cross-examination. The reason I paused your cross-examination there, and I apologize for doing it, but we were in this discussion, and I think it's while we're in the discussion and it's not lost, and I have to come back to it and say, recall when we talked about that. Well, I want to take you back to that. I just wanted to do it in real time. So forgive me, but I thought I should do it now, just for the sake of the clarity of the narrative.
No apologies necessary. We all want a clear record.
Thank you.
Who wrote the application, Mr. Atkins?
It was a team of people at the company and outside counsel.
Were you involved?
I was involved, yes.
At the time, were there discussions that we need to make sure we have the flexibility to time the bond issuance with our rate case?
I was not involved in every single conversation, and so I was focused on the particular application language, and I think that I was there when we inserted currently.
I'm sorry, there when the,
I was there when, yeah, I tend to recall that the page 43 of the consolidated application, I did see that particular qualification.
Can I ask another question? I only asked you if you helped prepare the application. Is it okay if I ask another question?
Yes, I did. Yes, I did.
Okay, thank you. If at the time P&M had expressed to you how important it was for P&M to have the flexibility to time the issuance of bonds so that they can issue the bonds to coincide with the completion of a rate case, would you have advised them to put that in their application under the section on timing of bond issuance?
At the time.
I'm asking you a hypothetical question.
Can't really answer hypothetical here. It's I think that there was a qualified estimate about timing, which, like any other estimate, and especially a qualified estimate, is subject to change. And so I think that that would be.
That's not what I asked you. Could you please answer my question?
I don't know if I would have made that recommendation because I think that there was already flexibility with the estimated, with the qualified estimate of time. So I don't think that that would be necessary.
Okay, thank you. I'm done.
Thank you, Ms. Sir. Up next is Ms. Nnazi, correct?
Yes, sir.
And I have you as requesting or having 15 minutes with Mr. Atkins.
Well, just to be honest, I took off 10 minutes and added 10 minutes to Joseph Terry. So I only have 5 minutes left. So, but I might need a couple more minutes. So I might need to take a couple of minutes from Ms. Sanchez because I see that this is going a lot longer with Mr. Atkins. So
right,
I have 5 minutes. So
thank you for your honesty. Go ahead, start your 5 minutes.
So Mr. Atkins, I have 5 minutes. I'd like to try to keep it to that. When you had an engagement with P&M in this case early on, and subsequently you were engaged again. Could you tell us how much money you're being paid for this testimony that you're giving, the written testimony, the rebuttal testimony, and your oral testimony?
I don't know if that is public information.
It's public. Please tell me.
I need advice of the counsel.
Mr. Hearing Examiner, could you please instruct the witness to answer the question?
May I have a moment to confer with Mr. Atkins separately from this, and I can listen to his concerns and see what they are.
And Mr. Hearing Examiner, if so, obviously, can I please have a time stop?
Yeah.
No, Mr. Alvidrez, what are you proposing? You're proposing to go offline and talk to Mr. Atkins?
Yes, and see what his concerns are.
That's highly unusual.
I understand, but he seems to have a concern.
Are the ratepayers ultimately going to be expected to be paying this?
I'm not sure.
No, Ms. Kins, are you prepared to answer the question?
I can answer. I think it is unusual, but I can answer.
Go ahead and answer it.
I have a total fee. I have a total fee of $150,000.
For you asked the question, Ms. Nnazi. $150,000 for what?
For this, for the particular testimony in this phase, oral and also written testimony for this phase.
Okay. Go ahead, Ms. Nnazi.
Thank you so much. you were involved in the very first securitization bond issuance in US history, correct?
No, I was involved in the first stranded cost of securitization.
I'm sorry, the first what?
Stranded cost. It was in 1997.
And that was with PG&E for $2.9 billion, correct?
Yes.
And Mr. Steve Fetter, who is my expert, the expert of new energy economy, was working for Fitch with you at the time that you worked on that securitization. Is that right?
I don't recall, but I think that is possible.
Isn't it true that PG&E was thrilled to get the cash for their stranded assets?
I do think that they were pleased with the transaction.
And once there was commission approval of full recovery for their stranded assets, they worked diligently to get the money as fast as possible. Is that also correct statement?
Every transaction is different. Well, but I believe that it did take a while after the order.
But they worked as quickly as possible to actually get the money, right?
I do think that they did proceed, yes.
Thank you. The ETA required that ratepayers assume the risk between the PRC approval of the financing order and the date of abandonment and bond issuance. Is that correct?
I don't know what you mean by take the risk. Excuse me, could you explain more?
Well, as you testified early on, and I cross-examined you about it, we didn't know, and you testified that you didn't know in 2019 what the interest rate for the bond would be in the future, like we don't know today, right? Because you don't have a crystal ball, right?
Right. I wish I did.
Okay, yeah, you'd be really wealthy. But
Miss, go ahead, ask the question, and then I'll interrupt you after the following colloquy.
Thank you so much, sir. And there was a required risk that ratepayers had to assume then, and that's sort of in the ETA, that between the issuance of the financing order and the time of the abandonment and bond issuance, there would be some time that would elapse, and we wouldn't know what the interest rate was going to be when the issuance of the bond actually was executed. Is that correct?
I would say that the interest rates of a future bond issue are uncertain, and that it is the overall cost in the particular terms of the bond issue that would set the ongoing revenue requirement that actually sets the energy transition charge, which are paid by existing and future customers.
Ms. Danazi, if you want any more time with Mr. Atkins, I have to ask you if you want to deduct it from another witness.
Thank you so much, sir. Could I take, I'll try this in 3 minutes, which would move my time down to Ms. Sanchez to 19 minutes.
Done.
Thank you. I really have just two more questions for you, Mr. Atkins. One is, in all of your experience with securitization bonds over the last 20 plus years or more, have you ever seen the completion of a rate case be a precondition before transition bonds are issued?
You know what, I just would not know about that.
Okay, that's fine. Let me just go into my other question then. You say that P&M has discretion as to when the bonds are issued. Can they wait 1 year, 2 years? How about ever? 5 years or ever?
I would say that P&M has expressed its intention to tie a rate case with the particular bonds. And so I haven't heard them say anything about 5 years.
But you know that they also have wanted to file a rate case, or allegedly wanted to file a rate case years before, and they chose instead to file a decoupling case, and they might choose in the future to file a rate rider of some sort. So we don't know what they're going to do, right?
They have stated their current intention.
Under your interpretation that they are allowed to issue the bonds essentially when they want to, and if it's tied to the rate case conclusion, where does that limit or deadline appear in the financing order or the recommended decision or findings of fact and conclusions of law?
Could you repeat that, the first part?
Under your
asking, I'm sorry.
Under your interpretation that P&M has the discretion to wait until the completion of the rate case, where does that appear in the findings of fact and conclusions of law?
Well, as the hearing examiner, as he confirmed, the statement of the case is all incorporated into the overall findings, into the order.
If P&M has the discretion to issue the bonds, essentially when it chooses to, does that have a limit or a deadline?
As I said, I think that there are about 9 instances in the ETA where there is a date certain, and there is not a date certain about the issuance of the energy transition bonds.
And one of those,
Am I done? And you're done. If you want more time, you're welcome to take it, but I have to take it from somewhere else.
yeah, I think I'll end there. Thank you, Mr. Atkins.
Well,
Thank you, Mr. Nazi. Okay, NM area. Ms. Gould, you have 45 minutes reserved.
Let me just put on a timer for myself.
I'm sorry?
If I could just put on a timer for myself so I can keep track of my time. Thank you.
Sure.
Good afternoon, Mr. Atkins. My name is Kelly Gould. I represent New Mexico Affordable Reliable Energy Alliance, also known as Nmprc. I wanted to follow up on some of the questions that other parties asked you in this case. So just to make the record clear, all of your references to the quote unquote rate case that you say is referenced in the financing order and in Pnm's application, that rate case was always qualified as a 2021 rate case. Is that correct?
It is my understanding that there was an intention to file a rate case in 2021, which would go into effect in 2022, along with the energy transition charges, all based upon qualified estimate about timing.
So is the answer yes? The rate cases that you're referring to were qualified by the year 2021?
Yes.
Okay, and I'm just going to ask you some questions about timing. You talk about in your 2022 direct testimony, pages 5 through 8, you talk about, well, let me ask you, let's turn to page 5 here. In this question, starting on line 6, there's a question, but if I'll direct you to lines 12 and 13, I'll just read it. It says, in my experience, it would not be reasonable to engage rating agencies in connection with securitization transaction more than 3 or 4 months prior to the planned issuance. You see that language?
Yes.
And then I wrote in my notes that you, I think when you're talking with Ms. Beatles, you said, or maybe it was somebody else, you said that was when you should start engaging rating agencies. It does not give a complete timeline. Do you remember that testimony?
Yes.
Okay. So I am now, sorry, I'll get to my point or my question, going to refer you to the 4. Well, so let me ask you then, what is the 3 to 4 months refer to if it doesn't refer to a complete timeline?
It refers to the estimated time for the particular rating process and the SEC process. And so I think that there is a lot of additional preparation work that is done prior to the start of the discussion with the agency, the rating agencies.
And preparation work, you mean on Pnm's end?
Yes, and the underwriters who have to be engaged, as well as counsel.
On page 6 through 8, you list different markers by weeks of steps, I guess, major steps. And so there's 15 weeks. If you divide that by 4, you get 3.75. Are these steps referring back to what you have listed here? The time it would take? What are these steps referring to?
Well, as I say,
Is this before, let me rephrase my question. Are these steps on page 6 to 8, would this be before or after the utility would begin to engage with the rating agencies?
I would say that it is a particular mix. And so I say that in weeks kind of 4 in weeks 4, you just might engage the agencies, but all of these are illustrative timeframes. And so
Illustrative, I'm sorry.
illustrative time frames.
Okay, so when I asked you, so when you had talked with Ms. Beatles and you said that in your testimony, it would not be reasonable to engage rating agencies in connection with a securitization transaction more than 3 to 4 months prior to plan issuance. And then you said that timing does not give a complete timeline. My question for you is, I know it's illustrative. I like your qualified answer, but I'm just asking for my own framework of trying to figure out the timeline here. Is the page 6 to 8, is that a complete timeline?
I would say that this is a particular timeline that is after underwriters have actually been engaged. And so I would say that in advance of week 1, that several weeks in advance or earlier than week 1 here, a Pnm would have actually engaged in underwriter. And so I think that there is an entire process where a company engages underwriter.
Is your answer no? This is not a complete timeline?
It is not a complete timeline, no.
Okay, so we've talked a lot about the 4, I forget what we're calling them now, the 4 factors on timing of the bonds. There's many sites to this. You can go to Ms. Eden's testimony. You can also go to page 20, number 28 of the financing order. And so what I just want to ask you about is number 1 has been complete, issuance of a final appealable financing order, correct?
Yes.
And number 2 will be completed either in June or September, unless something else happens. That's the current plan, correct? The abandonment of the facility will occur on the dates that PNM has said that they will abandon the facilities.
I would assume yes.
Okay, and then it's not a trick question. I'm just trying to see where we're at in the process. Number 3, delivery of any necessary SEC approvals under the Securities Act of 1933. Has that been completed?
No.
Huh?
No.
No. How long does that process take to complete?
Typically, it could typically take around 2 months, but that is after you give them a registration statement. And so it could take another 2 months or at least kind of 4 to 6 weeks in order to draft a registration statement. And so
has PNM drafted a registration statement?
I do. I am not aware of a drafted registration statement.
Okay, okay. So you're saying 2 months plus 2 more months. And so I'm talking about PNM here. So to complete number 3, your estimate is that it would take PNM 4 months to do that, approximately?
I would say that in order to do a registration statement, there has to be a collection of historical data. And so, and the underwriters need to be engaged. And so every company has a different amount of time that it takes to accumulate the historical data.
What would be like if they wanted to get it done in a timely fashion as quick as possible, what would be a good estimate, like an average amount of time that they could complete the necessary action items to complete number 3?
I would say about to complete item 3, I would say that an entire process from the start to collect historical data to closing is about 6 months. I would say that if you break out the particular rating agency process and the SEC process, it could be about 2 months.
I'm confused by your last answer. What do you mean by breakout? I'm asking about 3, delivery of any necessary SEC approvals under the Securities Act of 1933. What amount of time would that, how much time would that take?
They'll need to exclude things. So I need to exclude bond marketing. So that's 2 weeks, 2 to 3 weeks. So I would say about 6 months minus about 2 or 3 weeks.
Say it again.
I would say, thank you.
Yes, I would say about 6 months, also minus or 2 to 3 weeks. And so it's a little bit less than the 6 months.
So like 5.5 months.
Yeah.
Okay. Again, these are not trick questions. I'm just trying to figure out, PNM told us all they were going to issue the bonds at the Abandonment of San Juan. So I'm trying to figure out what's going on now, that the circumstances on PNM's end have changed. Has PNM started any of that process that is necessary for step 3 that you know of?
I do not know of any. I would refer you to company witnesses.
Other company witnesses? Is that what you said?
Yes.
Who? Who would know what if PNM started that?
I can't speak to that.
Okay. And then going back, I guess now we're on the recommended decision on financing order, page 121. I'm on number 4, completion of the rating agency process. How long would number 4 take?
Well, I would say that it would be concurrent with the SEC process, and so I would say 5.5 months.
Okay, great. So if PNM wanted to start now, a reasonable estimate of time that they could, if they started now, would be between 5.5 and 6 months. Is that your testimony?
I would say that is a general estimate that I would have.
And it could go faster or it could go slower.
It depends on a lot of the different factors. It depends upon third parties. It depends upon the SEC. And it depends upon their particular workload. And it also depends upon how much workload the agencies have. And with about 14 or 15 of these issues this year, I think that they have quite a heavy workload this year.
Okay.
These type of issues.
And so, do you think that PNM could do it in 2 months, depending on all those factors?
I would not expect that now.
Could you turn to NM area exhibit SC19? And this is an excerpt of the transcript in the hearing that we had around December 2019.
SC7, right?
SC19, 19.
C19, hold on. I think that I have to go online and get that one. And so 18.
Well, I can just, NM area exhibit 19, I can tell you what it is. It was when Ms. Eden was cross-examined.
I do have it. Yes, I have it.
Okay. Yeah, so if you turn to, on the top, the page is listed as 1015. And basically, the cross-examination was trying to get a similar timeline as what I'm trying to get from you. And I think you and Miss Eden are roughly in agreement. However, here on let me find it, hold on. Okay, and then it's so, sorry, let me direct you to page 1013. And on line 12, it says A, the registration statement will be for the special purpose entity. And then it says, oh, okay. And the rating process, how long does that take? And then Ms. Eden says about 2 years. And the what about, and then she says, I mean 2 years, I mean 2 months, sorry. So I was just asking about those 2 months that Ms. Eden references in her testimony, what those 2 months are. Is that the same as what you're talking about here on page 5, the 3 to 4 months?
I would say that that where you don't have a flood of issues, where we
have a what? Sorry.
A flood or a deluge of the securitization transactions which are being sponsored by an electric or a gas utility, an actual rating process would take about 2 months.
Okay. Thank you. And then I think later in that, she agrees with you that the whole thing would take about 6 months. You say about 5.5 months. So thank you for that clarification. And just to be clear, just because I don't work in bonds, the 6 months the 5.5 months, that would be for, like, PNM has not started anything, started day one. They could, depending on all those other factors, conceivably get the bonds issued within around a 6-month time frame. Is that correct?
Yes.
Yes. Okay, great. Thank you. And both the steps that we just talked about, the number 3 and number 4, are basically the timeline that we're talking about right now. That timeline is completely within Pnm's control. Is that your testimony?
No.
Excuse me. I mean, in terms of when they start.
Yes.
Okay. I have just one more question, and this is a follow-up on previous testimony that you had. I'm not sure who you were talking with, but you talked a lot about how there are words in Pnm's application that qualified the aspects of their application or their testimony. Do you remember that discussion?
Yes.
Okay. So my question for you is, how is the commission to make any decision if the facts underlying those decisions can change at any time?
As in every financing order, it sets forth an overall framework.
I'm sorry, please repeat that.
Sure. As in every financing order, the commission sets an overall framework, and so it does not specify every single thing.
And the utility must obey the parameters of the overall framework that's set forth in the financing order?
Yes, and also the ETA, and the ETA calls for estimates. Estimates are not a date certain or an amount certain.
Could estimates be an event certain?
No.
No?
No, an estimate is an estimate, and a current estimate is a qualified estimate.
But there is a framework with which within the utility must obey. Otherwise, there's no reason for a financing order. If the utility can do whatever it wants, it doesn't really need to seek a financing order from the commission, does it?
The overall framework, it deals with how long you can go with a scheduled maturity, and the order was specific with that. Also, P&M has an option to structure bonds with a shorter scheduled maturity. And the ETA and the order also gave a wide flexibility to set a legal maturity, which is the maturity that the agencies rate, that can be longer than the 25 years. And so that the legal maturity isn't set. And so, yes, as far as what is specified in the order and what is not based upon an estimate, yes, the applying company, a sponsoring company, has to comply. So they cannot do a scheduled maturity of 30 years.
Okay. Thank you for your testimony today, Mr. Atkins. That's all of my cross. Thank you.
Thank you, Ms. Gould. Sierra Club, Mr. Marks was excused for the afternoon. So up next would be the Attorney General, Mr. Elliott.
Mr. Hearing Examiner, I have just two questions. Mr. Atkins, who do you work with at PNM? Do you have like a regular point of contact there?
I did work with several people. And so, you know, it isn't only one person.
Who would those be?
I have worked with Lisa Edens. I've worked with Mike Setlitz.
I'm sorry, I didn't catch the first one.
Okay. Also Lisa Eden. Also Mike Setlitz. And Henry Monroe.
Debbie O'Rourke. I'm sorry.
Yes. Henry Monroy, Monroy, as well as counsel.
And was it primarily Miss Eden that you worked with on timing issues concerning the bonds?
I did not work on timing issues. In none of my, are you talking about the timing for the issuance, or as in what date? Excuse me, could you please explain? Or is it execution time?
Yes.
Execution timing, I just gave them my views, and I just put forth my views about execution timing, an overall outline in my direct testimony in this phase.
But your direct testimony in this case doesn't necessarily say or opine on when the timing should be for issuance, right?
Exactly. I did not testify either in the earlier phase of this case or in this phase about when bonds would be issued or when bonds were estimated to be issued.
But you, in the course of your conversations with the company, did you advise them on timing, what you thought would be appropriate?
No, I did not.
Well, that's all I have. Thank you very much, Mr. Atkins.
All right, then, thank you. And a wonderful child there, A name?
My co-counsel.
Oh, that's great.
Thank you.
Well,
Wonderful.
go ahead and enter an appearance, Mr. Elliott.
This is
I think
Eli
that-
Elliott, co-counsel.
This is who, I'm sorry.
Eli.
Well, thank you for that welcome appearance, Mr. Elliott and Eli.
Thank you.
Thank you, sir. Okay, San Juan Legislative Delegation. Mr. Powell?
Your Honor, I have no questions for this witness. Thank you.
Okay. Mr. Albright?
Yes, Mr. Hearing Examiner, I do have a few questions.
Okay.
Mr. Atkins, I'm Jeff Albright, J. Albright Law LLC, representing Bernalillo County. So getting a little bit late there in the day at your end of the nation.
It's all right. It's all right.
I want to follow up on a couple of questions that you've been asked and try to get some additional clarification. Have you ever advised another company to tie the securitization to a corresponding rate case?
I don't advise companies about rate cases.
And that wasn't my question. Have you ever advised another company to tie their securitization conditioned on having a rate case?
No, I haven't. No.
Okay, and I'd like you to turn to your testimony at page 6, please.
The direct testimony?
I'm sorry, yes, direct testimony, excuse me.
Yes.
And these are somewhat follow-up questions to what Ms. Gold was trying to get at as well, or in addition to, or maybe just some clarification that Ms. Gold was addressing. At line 5, you talk about the lead book running underwriter, the Pnm selects. What is the lead book running underwriter?
It just means that if there is more than one underwriter that is picked to actually market, to structure and market bonds, that there is one underwriter who is designated as the lead underwriter. And that particular lead underwriter works closely with the company to structure the transaction, to work on the particular rating agency presentation. It reviews documentation and also makes comments on documentation, and then the phrase book running relates to the actual marketing process, which is a transparent process where there is either one or two lead underwriters, or sometimes three, but in this size transaction, I think that there will likely be one lead. That underwriter's marketing and syndication desk will take orders from investors, and all of those orders and indication of orders are accumulated on a ledger, which is called a book. And so it is a book of investor orders. And then there is an allocation process, and, bonds are priced. And therefore,
Okay.
It refers to the kind of lead underwriter. Yeah.
Okay, so in a securitization of the size that we're looking at here, would you anticipate that there would be more than one underwriter?
Yes, I would anticipate that there would be more than one, but
And
I
is
would,
that normal and why?
because I think that issuers, they have a set of relationships with existing banks, and it is typically good to have more than one investment bank in order to increase marketing power, and so to try to get more orders in. And if you get more orders in, you can have investors compete in order to try to get bonds.
Okay. And then looking a little bit later there, same page, page 6, where you're looking at the preliminary registration statement. Well, let me just read the statement. And lines 10 and 11, it states transaction timing may also be affected by the SEC, which undertakes a review process of the preliminary registration statement. Did I read that correctly?
Yes.
Okay, so first of all, how long does it take the SEC to prepare the preliminary registration statement? And at what point in the process is that done? Is that done concurrently with the other activities that are going on, or when does that start?
Well, the registration statement is prepared by the sponsor of the securitization, which in this case would be Pnm, along with Pnm's counsel. And so it would be the registration statement of the special purpose entity, which is created by Pnm, but it's likely that the Pnm would also be a co-registrant. And so all of that work, it takes weeks in order to get all of the information which goes into the registration statement, which is like an offering document.
All right, and how many weeks in general?
It could take, it depends upon how long a company takes to accumulate all of the required historical data. It is historical data which could go back as far as 10 years. And so all of that historical data has to be collected, it has to be analyzed, and so it has to be put in a form where it can go into the registration statement. And a lot of transaction documents are also summarized. The indenture is summarized, the servicing agreement is summarized, and there are certain of the legal opinions also summarized. And so a lot of transaction documentation, at least in a draft form, has to be done in advance of actually filing a registration statement with.
Okay. All right, let me move on to another question I had. Been the position of P&M that this is tied, the securitization is tied to a rate case. You agree with that?
That is what P&M has testified, and then that is what is in the.
Okay. Did you listen to this morning's hearing at all?
Yes, I did. I did not hear every word, but I did listen in.
Okay. Do you recall, for example, there were a number of elements with regard to revenue, impacts on revenue that PNM had listed as potential revenue issues that were asked by both New Energy Economy, and I think there was someone else that went through the details on that. Do you recall that general discussion?
Yes, I think that some of it kind of went over my head. But
Okay. This afternoon, one of those items, as you may recall, was with regard to decoupling. And this afternoon, PNM filed an appeal of the decoupling case, which obviously would affect any rate case. So what effect would the appeal at the Supreme Court have on tying this case when that element in the rate case might not be decided for a year and a half? Don't know. So would it have any impact from your perspective?
Mr. Hearing Examiner, I think this is very far afield of what this witness has testified about. And I suspect he doesn't have any knowledge about decoupling or appeals or anything of that nature either. I also, wondered how my notes show that Bernalillo County only had 10 minutes with this witness, that they gave away 5 for Mr. Monroy, and I was sort of wondering where we're at in that process as well.
I hadn't deducted
From Ms. Sanchez, I believe.
No, you took extra 5 with Mr. Monroy, and you took it. Oh, I beg your pardon. Yes. It was not. It was from Ms. Sanchez. I apologize.
It's okay. It's hard to keep track of all of this, as you know.
I apologize, but my objection still stands.
All right. Did you just mention the decoupling, Mr. Albright, to note that PNM had appealed my
That's
decision?
correct. Yes.
I'm just kidding. But why
I didn't do it
else?
just for that. The question goes back to a few of the questions that were asked.
I don't understand the linkage any more than Mr. Alvidrez does.
The linkage goes to the fact that the next rate case could very well be affected time-wise, which would lead to further delay with regard to securitization if securitization is tied to the rate case. And decoupling is certainly tied to the rate case.
Okay, so rephrase the question then.
Let me try to rephrase the question. If there are other circumstances that could impact the rate case and delay the rate case, do you think it's still appropriate to delay the securitization to the next rate case? Back to similar questions, if it were a year and a half delayed, 2 years delayed, 3 years delayed?
I cannot speak to what is or is not appropriate. All that I can speak to is what I read in the order.
In the what? I'm sorry.
Order.
Order?
Oh, that's in order.
And to the best of your knowledge, has PNM selected any underwriter at this point?
I did not have the knowledge, no.
Do you not know, or to your knowledge, they have not?
I don't know.
Don't know, okay.
Two minutes, Mr. Albright.
Thank you, Mr. Hearing Examiner. From your experience in looking at the securitization and what's happening in the markets right now, would you anticipate that the bond ratings for securitization will go up or go down if they are delayed to the end of this year?
The particular timing of an issue would not have an impact on whether the bonds are AAA or not.
And the rating is the high rating is because they're secured by the customers, correct?
It is because of the overall, the statutory framework and the order which outlines statutory property and an irrevocable financing order. And also a non-bypassable customer charge.
Does the high rating that's assigned to the bonds decrease the cost of securitization at all, or is that process sort of fixed financially?
Higher ratings, the AAA ratings give you an opportunity to try to achieve the lowest market clearing price.
Now, I understand that, but my question is, does it decrease the procedural costs of going through the various steps, or doesn't make any difference?
No, I think that the agencies will charge what they charge if it ends up being rated a AA. And all of the other transaction participants will charge what they charge.
Okay. And what about utilities?
And anything, Mr. Albright, anything else will have to be taken away from Ms. Sanchez, Settlage, or Reynolds? Because we're beyond the 15 minutes.
Okay, I have some other questions, but I can refer them to other P&M witnesses. So thank you, Mr. Herring-Zemmer. Mr. Atkins, thank you very much for your testimony this afternoon. Appreciate it.
Thank you, Mr. Albright.
Thank you.
All right, let's see. Mr. Borman, you have any questions for Mr. Atkins?
Thank you, Mr. Herring-Zemmer. I do not have any questions for Mr. Atkins.
Okay. All right. Thank you, Mr. Borman. Mr. Schanauer?
I have no questions either. Thank you.
Okay. Now, Mr. Atkins, you're reading the financing order. You don't see the bond issuance as being legally inextricably tied, linked, connected, synced to the disposition or conclusion of the rate case, do you?
I just see that.
I just want to clear up that confusion, if there is any.
I just read what I read, and then what I read is that the supporting testimony and the statement of the case, it does mention that the energy transition charges are intended to coincide with the resolution of the rate case in 2022. And so I don't know about legally binding. I can just read what I read.
But the interim rate credit provision, which is based on ETA section 4B11, provides that if P&M has not, and I'm looking at page 84, page 85 of the recommended decision now. And this is where that linkage, I think, decouples, if you will, delinks. If P&M has not adjusted its base rates charged to customers in a general rate case to reflect the abandonment of the remaining San Juan plant before the start date of the ETC charges, reflect the abandonment, which is represented to be back in this case in June of or June 30th, 2022. P&M shall be required, reading again from the financing order. PNM shall be required to implement an immediate credit to ratepayers as an interim rate adjustment mechanism upon the start of the ETC charges. Do you see that?
I'm trying to find where this is on page 85. I'm sorry.
It's on page 84.
Oh,
The last paragraph starts the hearing examiners recommend, and I was reading from the next sentence.
oh, okay, okay. Hold on. It says here, I say that it says that the credit
Right,
will go into effect as upon the start date of the ETC charges.
right.
Sorry, the
But
what?
it's
The what of the ETC?
Upon the
start date.
yes. Oh,
The start.
go ahead, please.
No, the start date of the ETC charges
Yes.
is what the order reflects. And so the linkage, the syncing of the issuance, bond issuance to the rate case, that's entirely within the discretion of PNM, of the company. That's not something that's required or set forth or provided for in the financing order. Isn't that correct?
I have not seen a phrase with the will, well, a phrase with a shall, and so I've not seen a mandate. I think that the order takes into account estimates which are made in good faith about a set of things which were expected to occur in 2022.
But the interim rate adjustment mechanism, the section 4B11 mechanism that I call it, or the interim rate adjustment mechanism, doesn't make sense if there's a ironclad or a connection or linkage between the rate case and the bond issuance. You see what I mean? Because otherwise that interim rate adjustment mechanism is illogical, because it's provided for if there isn't that linkage.
Well, it just talks about the particular start date of the ETC charges.
Right, but it also talks about it also encompasses what happens if there's a bond issuance outside the context of the general rate case, right? If the adjustment has not been made in a rate case, it's going to be made by this interim mechanism, basically.
I see what it says there, yes.
And that's what it says.
It says that there, yes.
Okay, and then that leads me to, everybody here knows, but just for the record, you were PNM's expert witness in the Four Corners power plant securitization and abandonment case, right?
Yes, I was.
And that was case number 21-00017-UT.
Yes.
And that same mechanism was adopted by the commission in the financing order in that case. That same mechanism being the one I'm referring to here, the interim rate adjustment mechanism, the section 4B11 mechanism. correct?
I have not really looked at that order. I did not think that there was an order there. I could be wrong.
Well, there wasn't one adopted by, and there was not one adopted by the commission. There was a recommended decision, which is on appeal. And PNM is asserting, I think, that the recommended decision, at least with regard to the financing order, should go into effect. They're challenging the commission's rejection. So anyway, you advocated, the company advocated for adoption of the Section 4B11 mechanism, right? At least that's what I recommended. And that was not challenged by PNM. Is it, can you accept that?
I do see that on page 84.
All right. Assuming that the Section 4B11 mechanism was recommended, right? And the commission did not reject the abandonment and securitization on that basis. That is the same interim credit mechanism, rate adjustment mechanism that would be applicable in both cases. Let's assume that for the sake of argument. Can we assume that? It's not, this isn't the controversial part, Mr. Atkins.
All right, I'm listening. Yes.
You might have even, there might have even been an objection lodged by Mr. Alvidrez to that if it were, but it's not. My point is that linkage, that syncing of the rate case that PNM purported in the San Juan case, we're trying to apply in the Four Corners case basically the same law, right? The ETA.
Yes.
Right? Why wasn't that same linkage to the rate case emphasized in the fall of 2021 when you testified in case 21-00017-UT, if we're dealing with the same law?
I don't recall testifying about the estimated timing of any of these the bond issues. And so I did not really testify to any of those matters, for that matter.
But there wasn't the same emphasis or alleged emphasis on tying the bond issuance to the rate case, any particular rate case timing in the Four Corners abandonment case.
I don't recall the supporting testimony there. I did not have in mind, so.
I agree. I don't recall it either. That's the point. That's perhaps the controversial point.
I don't recall whether it was there or not.
What if it weren't there? What would that suggest to you as an expert in securitization?
That was filed in 2021, right?
I'm sorry, that was filed in?
In 2021, the Four Corners?
Yes, and we went to hearing after the Evangrid PNM merger hearing in the fall of 2021.
Right. I cannot really speak to that. I think that the pandemic, was going on at that time.
Still is, actually, isn't it?
Yes. I'm still wearing a mask. I wish that more people would wear masks.
Yeah. All right, Mr. Atkins, thank you so much. Mr. Alvidrez, do you have any redirect?
No, sir. Thank you.
Okay. Hopefully no other follow-up for Mr. Atkins. Okay, Mr. Atkins, it's always a pleasure to see you. Thank you so much for your testimony, sir.
It is great to tie into the great state of New Mexico. So
Thank you. All right.
I'm- Well, thank you.
All right. Take care. All right. You're excused. Okay. Let's take the 15-minute afternoon break. We'll be back at 3:40 with Ms. Sanchez. Thank you. Good afternoon. We're back from our afternoon break on the second day of this hearing. Ms. Terwilliger?
Yes, thank you, hearing examiner. PNM calls Laura Sanchez. May the witness be sworn, please.
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Sanchez, can you state your name and title for the record, please?
Yes, my name is Laura Sanchez, and my title is Chief Policy and Legal Advisor for PNM Resources, Inc.
I'm sorry, please repeat all that.
Oh, I'm sorry.
Can
Can you
we-
hear me okay?
Yes, I just need you to slow down just a little. I'm tired.
Can we hold up for a second? We had some background noise. I don't know if it was from Ms. Terwilliger or from one of the other folks on right now. So let's see if that has gone away. Okay, go ahead.
Me, I'm sorry, me, you're Mr. Hearing Examiner? Okay.
It's not you.
It's
It's
not
not
me.
coming from you, right?
Would you like me to go ahead and state my name, or are we doing a sound?
Yes, please.
Okay.
But I'm still hearing a hissing in the background that I'm not sure where it's coming from. But please do go ahead.
My name is Laura Sanchez, and I'm the Chief Policy and Legal Advisor at PNM Resources, Inc.
And is the sound gone now?
Yes, ma'am. It
Okay.
is.
It was a heater. It's freezing in the PNM offices, so I turned it off.
Well, you can turn it back on. That's okay. I don't want you to freeze.
That's okay. I'll be all right. Thank you. Ms. Sanchez, did you submit or cause to have submitted pre-filed rebuttal testimony, which has been labeled or marked as PNM Exhibit SC5?
Yes.
Are there changes or corrections to that testimony?
Sorry, no, I do not have any changes.
And if I asked you the same questions today, would your answers be the same?
Yes, they would be.
And is your testimony true and correct to the best of your knowledge?
Yes, it is.
I move for admission of PNM Exhibit SC5. Mr. Hearing Examiner?
Any objection?
Yes, Mr. Hearing Examiner Kelly Gould for NM area. For the record, I would like to note my standing objection to this witness's legal testimony.
Thank you. Ms. Gould, as you know, that objection has been ruled on, but you've made it for the record and I respect that. So with that objection and hearing no other objections, PNM Exhibit SC-5 is admitted. Passing the witness for cross-examination, Mr. Williger.
I'm sorry, I skipped that step. Yes, I the witness for
It's okay.
cross-examination. Thank you.
Okay, that's okay. Okay, up first, we have 15, I have 15 minutes of WRA time. Ms. Beatles,
Yes,
is
thank
that
you.
correct? Sure.
Yes, thank you, Mr. Medeiros. And good afternoon, Ms. Sanchez.
Good afternoon.
Please turn to page 3 of your rebuttal testimony, your May 18th, 2022 rebuttal.
I'm there.
And starting at the top, you state that you were involved in the drafting and passage of the ETA referring to the Energy Transition Act. Is that correct?
Yes.
And would you agree that Noah Long and Steve Michael were also involved in the drafting and passage of the Energy Transition Act?
Yes, they were.
Do you recall meeting with me? I think it would have been in late 2018, maybe early 2019, during or around the legislative session that eventually passed the Energy Transition Act?
I remember meeting with, I know that we met, Ms. Beatles. I don't remember exactly when it was, but we probably had several meetings during that time. My memory's a little bit fuzzy.
And do you recall that I was working for the PRC staff at the time?
Yes,
And do you recall that I criticized the ETA because it removed PRC authority to decide whether and how much undepreciated investment PNM should recover when San Juan is abandoned?
I believe that was one of your concerns, yes.
Would you agree that allowing PNM to recover 100% of its undepreciated investment through bonds without having to litigate recovery before the PRC is a benefit in the ETA to PNM?
I believe that that was an issue that we were working on in the ETA. So it was a trade-off that we were looking for that incorporated a number of benefits, as all legislation does. But yes, that was one of the items we were pursuing.
And yes, it was one of the benefits to PNM, right?
That was my answer, yes.
Okay, thank you. So of course, you're aware that the merger between PNM and Evangrid has been denied, at least for now, right?
I'm aware of that, yes.
And it's on appeal at the state Supreme Court, right?
Yes.
But in the meantime, the merger agreement has been amended and extended by PNM and Evangrid, right?
That's my understanding.
Are you aware that section 5.1 of the merger agreement requires PNM to use commercially reasonable efforts to maintain its relationship with governmental entities?
Objection. Hearing examiner, Ms. Sanchez's testimony did not discuss the merger agreement in any way. I think this is going beyond the scope of Ms. Sanchez's testimony.
Ms. Beatles, I'll allow you to link it up, but it isn't related. I don't think her testimony addresses the merger.
Well, Ms. Sanchez is the chief policy and legal advisor for the company, and to take a position now that is inconsistent with representations made to the commission in its application for a financing order is not commercially reasonable efforts to maintain its relationship with governmental entities as the merger agreement requires.
Objection overruled.
So are you aware, Ms. Sanchez, that that section 5.1 of the merger agreement requires PNM to use commercially reasonable efforts to maintain its relationship with governmental entities?
I have not read the merger agreement. I'm not familiar with that particular or really any part of the merger agreement.
Have you looked at the merger agreement?
I have not.
I have no further questions. Thank you.
Thank you, Ms. Beatles. Up next is CCAE and Prosperity Works.
Thank you, hearing examiner.
Sure.
I have a few questions for Ms. Sanchez.
Okay, I have you down for 60 minutes, but sounds like you don't have that long.
We may not take that long. It depends on the responses.
Okay.
Okay. Hi, Ms. Sanchez. My name is Kara Lynch, and I'm attorney for CCAE and Prosperity Works.
Good afternoon.
Good afternoon. I was wondering if you could turn to the recommended decision on the financing order, which is PNM Exhibit SC -9.
I have it in front of me.
Okay, fantastic. So I think if you turn to page page 10 of the recommended decision, the hearing examiners begin section 2 which is labeled background and legal framework, correct?
Yes.
Okay, so the legal framework here provides the basis upon which the financing order should be made. The decision for the financing order should be made, correct?
I believe, yes, that it provides the background and legal framework for the overall recommended decision.
Okay, so here we have a framework for the application of the Energy Transition Act, correct?
Yes.
Great. So if you could now turn to, let's see, page 4 of the recommended decision. Okay. Here we have, if you can follow, on July 19th, PNM filed its consolidated application for the abandonment financing and resource replacement of the San Juan Generating Station pursuant to the Energy Transition Act, correct?
That's what it says, yes.
Okay, and A, B, and C on page 4 outline the request PNM made. Correct?
Yes.
Okay. Just on page 5, if you could read the first sentence to me, I'd appreciate that.
Ms. Lynch, do you mean the first sentence of the first full paragraph or the?
Yes, just after, section C above.
Okay. On July 10th, 2019, the commission issued a corrected order on consolidated application whereby the commission bifurcated the review of PNM's application into 2 separate proceedings.
Okay, I'll continue. The abandonment and securitization issues, items A and C above, are addressed in this proceeding, case number 190018 UT. Correct?
That is what it says, yes.
Okay. What is the effect the corrected order had on the consolidated application?
I'm sorry, the correct.
What occurred here? The commission issued a corrected order. What was the effect of that corrected order?
I think you just read that. I assume that you're talking about the fact that it got separated into 2 different cases.
Right. So, and would you agree that the effect is that the commission was therefore making a decision on the abandonment and securitization issues here in this case, 190018?
Right. So they made a determination to separate out the abandonment and securitization and the replacement resources into 2 separate cases.
Okay, fantastic. Now turn to page 14.
All right.
Okay, I'm still navigating there. In the, oh, I'm sorry, I actually meant please turn to page 15.
All right.
In the section describing the financing order, would you mind reading that first paragraph?
Sure. Given that the primary focus of the ETA is to establish a mechanism for PNM to recover the costs of abandoning the remaining units of the San Juan plant, the ETA defines the proposed securitization mechanism with precision. It also, I'm sorry.
That's fine, just that first statement. What does that sentence mean to you?
I think that it means that there is a basically the ETA establishes a new framework for the PRC to use for the financing of the cost of abandonment. That's what the ETA is about.
Okay, so, and you agree that it's a securitization mechanism that provides precision?
Yes, I mean, the ETA sets out a framework for securitization and it's pretty precise.
Okay, fantastic. Now, within the recommended decision, the ETA is described for us, and there are many citations to the ETA. If you could turn to page 16. Okay. Which at footnote 21, section 2L provides the definition of a financing order. Would you mind reading that definition for us?
That's footnote 23.
Oh, that is 23. Apologies.
Thank you. Yes. So would you like me to read footnote 23?
Yes, it's the definition of the financing order in the Energy Transition Act.
Sure. So subsection 2L defines the financing order as an order of the commission that authorizes the issuance of energy transition bonds, authorizes the imposition, collection, and periodic adjustments of the energy transition charge, and creates energy transition property.
PNM submitted its application for a financing order because it sought energy transition bonds, correct?
Well, it submitted an application that requested a financing order that would implement a number of things. So it would create a special purpose entity. It would create energy transition property, would be part of, that would come from an energy transition charge. It would also create bonds that would be issued by that special purpose entity, which is a subsidiary, would be a subsidiary of PNM. And then it would issue, the SPE would issue the bonds. So it was a number of different things that were part of that securitization mechanism.
And we're here today because PNM has chosen not to issue the transition bonds. Correct?
Well, we're here today because of a show cause petition that asks us to explain why we have made a decision about the bond issuance and the energy transition charges.
Okay, so this recommended decision tied the securitization, which are the bonds, to the abandonment of San Juan. Would you agree?
I think that it authorized the issuance of energy transition charges that would then be issued by bonds. It also froze in place what the abandonment costs would be. That's spelled out in the ETA. So yes, that was part of, I mean, you have to have the abandonment in order to have the abandonment costs. And so that then was what determined what those costs would look like when it was part of the overall amount that would be financed.
Okay. Do you think that when the financing order was sought and certain facts were provided for the basis of that financing order, it was commonly believed that PNM would issue bonds to securitize the abandonment of San Juan 1 and 4, San Juan units 1 and 4?
That it would be that it was commonly understood that bonds would be issued
to securitize the abandonment of San Juan units 1 and 4.
I think securitizing the abandonment costs has yes, that was the purpose of the application.
Okay, and in most people's minds, wouldn't the abandonment occur at about the same time that the bonds would be issued? So it was commonly understood that the bonds would finance the abandonment at approximately the same time as the abandonment.
Well, I'm not sure what commonly understood means in this context, but I'll say this much. So at the time that the application was submitted, and I think as has already been made clear through, I believe, Mr. Atkins's testimony, excuse me, just a moment. Oh, allergies. All right, so as is made clear already, there were several references in the recommended decision to points in the record where there was mention of an intent to file a general rate case. There were 2 rate cases that we, at that point, this is back in 2019, expected to file. One of them was in 2020, one of them was in 2021. So I think that at the time, and this is a little bit sort of like hindsight review, right, where we are now, at the time that we were looking at the, that we were all talking about the application, we were anticipating that there were at least 2 rate cases that were going to occur that would provide an opportunity for the San Juan generating station to be taken out of rate base. So I think that that was the presumption that we were moving forward with.
Okay, I appreciate your time and your explanation of how the rate cases would play into this. PNM has not initiated a rate case, correct?
We have not filed a rate case. Is that what you mean? I'm not sure what
Yeah, filed is comparable to initiate.
We have not filed a rate case, right?
Do you have any sense for when PNM might file its next rate case?
We are anticipating filing of a rate case on or around December 1st of this year.
But you can't make a firm commitment to that, can you?
My understanding is that we will be filing a case. Again, I can't make a determination as to the exact date. I think that's the issue I'm struggling with. But right now, our expectation is to file a rate case on or around December 1st, 2022.
Okay. Ms. Sanchez, I appreciate your time, hearing examiner. I have no further questions.
Okay, thank you, Ms. Lynch.
Yep.
Ms. Benazi? I'm trying to find, I've got so many things on screen, but memory serves 19 minutes, is that right?
Exactly. Thank you. If I could just have a second to get my notes together here, because I was expecting a little bit longer.
Haven't started the clock yet.
Thank you. Okay. All right. I'm ready. Thank you so much, sir, for that slight delay. Good afternoon, Ms. Sanchez.
Good afternoon, Ms. Manassi. Can I just say that is your color?
Thank you very much. So you are a lawyer, correct?
I am guilty as charged.
And you said that it was Pnm's intent to file a rate case and to coordinate that with the energy transition bonds, to have that those be synced. Is that correct?
Well, I don't know that I used the word synced or coordinated, but I did say that the expectation at that point, or the assumption that I think we were functioning under, and that's part of the recommended decision, cited several places, was that there would be a rate case. There was actually 2 rate cases that were being planned, and that at some point within those rate cases, there would be an effort to remove San Juan from rate base.
Yes, that's true. You didn't use those words, but you didn't mention the word that I really want to focus on, which was intent. So it was the intention of PNM to coordinate these events. Is that right? And PNM testified to that.
Okay, I mean, I'm not sure that we can sit here and play different words and, whatever. I said assumption, but I think there was an expectation, an intent, a plan, if you will.
And an intent or an expectation is different than what the law provides, correct? Those are 2 distinct ideas under the law.
I think that the law has very prescriptive requirements, and the ETA does not explicitly discuss the requirement of a rate case, if that's what you're getting at. But we also have authority under other parts of the PUA with regard to rate cases, and in general, in terms of rate making mechanisms, we expect a cost of service to be considered when we're removing an asset like San Juan. So there is a difference between intent and compliance with the law, I suppose.
Yeah, so let's talk about that. Do you have the ETA or SB 489 before you?
I have the ETA.
Okay, so I did a word search in there, and I found that the only time that the ETA addresses a rate case is under section 6A.
Are you saying 62-18-6A?
Yes. And without reading the whole thing, would you agree with me that this section regards the allocation of the cost allocation methodology should be consistent with the utilities' most general rate case?
I'm sorry, I got distracted for a second. Can you repeat your question?
So I did a search in the ETA, and I did not find any other reference to the word rate case other than in this section, in section 6A. And without reading the whole thing, what I wanted to ask you is, does this really refer to the cost allocation methodology should be consistent with the utilities' most general rate case? Generally, is that what this is about?
It talks about the allocation in the most recent rate case. So that one is sort of backward looking. But I do want to say, and I don't disagree with you necessarily that the term rate case isn't mentioned elsewhere, but there is cost of service mentioned elsewhere. And so there is, and I think we've had testimony along these lines, but there's been sort of a reference to rate case, or at least the fact that you determine the overall cost of service in a rate case. I think that's referenced in other places without the term rate case necessarily. Okay, but you're acknowledging that what I had said about 6A is correct. Is that right? Yes, I think 6A talks about the most recent general rate case allocation method. But the Energy Transition Act, the purpose of it is to transition from
coal-fired generation for P&M, isn't that right? And it applies only to P&M with regard to securitization and San Juan and Four Corners. Is that correct?
I think that's an accurate interpretation.
And its underlying intent was to promote the abandonment of those two facilities. And just like Ms. Beatles asked you, the sort of quid pro quo was, if the utility would abandon those facilities, we'll give you a deal on your stranded assets. Essentially, isn't that right?
I agree with you that the primary purpose, or one of the major goals of the ETA, was transitioning out of coal. And consistent with the way I answered Ms. Beatles' question, yes, the utility had an interest in recovering stranded costs, and securitization was a low-cost mechanism to do that with.
And it was a low-cost method because P&M promised the legislature, the commission, and the Supreme Court that there would be customer savings. Is that also correct?
I'm hung up by the word promised. We represented, so we, in many discussions, and I've testified to that in my my rebuttal, but we had many conversations and discussed throughout all of our discussions that there were customer savings.
Could you please turn to 6218-2H?
In there?
This is the definition of energy transition cost, correct?
Yes, that's what 2H is.
And the first one is financing costs, and the second one is abandonment costs, correct?
That's correct.
So the energy transition costs is the sum of financing costs, abandonment costs, correct?
Well, and there's two other.
We'll get to that in a minute. I'm not trying to neglect that. We'll get to that. But so far, that's what it says. Is that correct?
So far, yes.
Okay. And other costs that are related to the energy transition cost definition is under C and D specifically. And those are undepreciated investments as of the date of abandonment, correct?
As of the date of abandonment and the qualifying utilities, books and records, right? There it goes on, but yes, that's part of it.
And then D also talks about other undepreciated investments, ... prior to the facility's abandonment, correct?
That's the last part of it, yes, prior to the facility's abandonment.
And then if you could go to K4.
I'm sorry, did you say K4?
Yes, please.
Okay.
So that is talking about what financing costs means. And in that definition, specifically in K4 of that definition, it talks about that the P&M can obtain an order approving abandonment for a qualifying generation facility, correct?
It says specifically costs, fees, and expenses related to, and then it spells out a whole lot of stuff. And then at the end, I believe that costs, fees, and expenses can also be attributed to obtaining an order approving abandonment of a qualifying generating facility.
And if you would go to S of that same section, and please go to 3. I'm going to ask you about 3 and 4. What is your?
I'm sorry, S is in Sam?
Yes, please.
Okay.
So S says a qualifying generating facility means a coal-fired generating facility in New Mexico that may be composed of multiple generating units, has a CCN, is owned or leased in part, and then 3. What does 3 mean?
Well, if I could just read it out loud, if operated by a qualifying utility prior to the effective date of the energy. I'm sorry. Yes, I do that. I apologize. So number 3, if operated by a qualifying utility prior to the effective date of the Energy Transition Act is to be abandoned prior to January 1, 2023.
What does that mean?
That has been interpreted to apply to San Juan Generating Station.
And that's what you believe, and that's what P&M believes, right?
That's certainly what I believe, and I think most people who are considering the ETA, applying the ETA, believe that's what that means, yes.
And so that means that the ETA only applies to a facility that has been abandoned. We'll get to 4 in a minute, but has been abandoned prior to January 1st, 2023, correct? We'll get to 4 in a second.
Yes.
Other than 4. And you knew that the operating agreement, the co-tenancy agreement, lots of other agreements ends for San Juan Generating Station in July or June, actually, June 30th of 2022, and has just been recently extended for 3 months. Other than that extension, that's when all of those agreements had ended. Is that your understanding?
Yes.
And now let's go to 4. 4, you can read it, but it is the same exact thing, but it goes to January 1st, 2032. And is it your understanding that that applies only to the Four Corners power plant?
Well, it's not the same exact language because it does say if not operated by a qualifying utility. So just with the caveat that, as we all know, Four Corners, we are not the operator of that plant. But yes, that applies to Four Corners.
And so all of
5 minutes, Mr. Nazi.
Thank you. All of the definitions regarding financing costs and the purpose of the Energy Transition Act refer to P&M abandonment of San Juan and Four Corners. That's what it's pegged back to? Is that correct?
I don't think that's been in dispute. We've been talking about abandonment.
Okay. Securitization has been used successfully around the country for abandonment of plant as well as for natural disasters. Is that correct?
Yes, it's been in addition to those natural disasters, but also infrastructure expansion, rebuilding, however you want to characterize.
And you said the purpose is to address cost shocks whether from stranded assets or wildfires. Is that correct?
In some cases, it's been used for that, yes.
Because we want to try to protect ratepayers from cost shock. Isn't that true?
I think in general, we probably all want to, yes.
Did you read Mr. Fetter's testimony?
I did.
Okay. Could you go to the portion of his testimony? It's on. Sorry, let me just find it. Did you read the compliance filing? Let me just ask you this. Did you read the compliance filing that PNM made on April 6th, 2020 in this case?
I'm sorry, was that part of the testimony you're asking me about?
No, I just want to, I will, this is just an introduction question. Yes. Did you read the April 6th PNM compliance filing?
I'm sorry, is that an exhibit?
I just want to know, did you ever read the compliance filing by PNM in this case? It was filed on April 6th, 2020. It was after the final order was approved and there was a compliance filing filed, I believe, like 5 days later. Did you ever read that?
Hearing examiner, may I? This is coming up because Ms. Nanasi alerted Mr. Alvidrez sometime.
Please make an objection. I only have a minute and a half left. I just make your objection and please let the hearing examiner rule on it.
Well, my objection is Ms. Nanasi is trying to cross Ms. Sanchez on a document that just was uploaded around lunchtime today. And that's not in compliance with your procedural order. It's,
I'm not going to do that. I'm not going to do that. So do you have any other objection? Okay. Did you read the compliance filing that PNM filed in this case? It was cited in Mr. Fetter's testimony.
I did not.
Okay. Could you look at page 14 and 15 of his testimony? And there's a question about the compliance filing. And there is a specific part that is quoted from the compliance filing. Mr. Hearing Examiner, I see that I have just 30 seconds. So since I really don't have anybody else to cross-examine, I guess I'm going to have to take my 3 minutes from Mr. Settlage. Can I have that, please?
Yes, ma'am.
Thank you. So that will be 0 for Mr. Settlage. So let me just ask you this. Here it quotes from, and in Mr. Fetter's testimony, it quotes from the compliance filing by PNM. And if you could just read on page 15 of his testimony, line 13, could you please just read that part?
Out loud?
Yes.
Okay. If PNM has not adjusted its base rates charged to customers in a general rate case to reflect the abandonment of the remaining SJGS plant before the start date of the energy transition charges, PNM shall implement an immediate credit to customers in the amount of its cost of service related to SJGS units 1 and 4, parentheses, including capital, operations, and maintenance, and all other expenses, close parens, as an interim rate adjustment mechanism upon the start date of the energy transition charges. The rest of it too?
There's one more sentence. Yes,
Okay.
please.
This credit shall remain in effect until the conclusion of PNM's general rate case that includes the full cost impact of the abandonment of SJGS in PNM's base rates.
So when you read this in Mr. Fetter's testimony, did you go back to the compliance? Did you have any reason to disbelieve that this was a proper quote from Mr. Fetter of Pnm's compliance filing? Let's just start there.
I had no reason to doubt that. It's similar language to what's in the recommended decision, so it was not unfamiliar.
Correct. And there was a requirement by this commission that Pnm file a compliance, make a compliance filing. I think it was within 10 days, but make a compliance filing to acknowledge and to agree to the amendments made by the hearing examiners, a specific filing, and Pnm actually did that. Is that correct?
That's correct.
No further questions. Thank you very much.
Thank you, Ms. Nanazi. The Attorney General, Mr. Elliott. Do you have any questions for Ms. Sanchez?
No, I have no questions. Thank you.
Thank you.
Greetings to your co-counsel.
Yeah,
Very cute.
that's right. San Juan Legislative Delegation. Ms. Chappelle?
Yes, yes, Your Honor, I do have a few questions.
Okay, go ahead. I have you down for 10 minutes.
Yes, sir. Good afternoon. How are you doing?
I'm good. Very nice to see you, Mr. Powell.
Great to see you too. Just a quick couple of clarifying questions. Going back to the testimony from the first day, and I apologize, Mr. Monroy, I believe his name is, he was talking about the decision of certain agencies to go ahead and wait to take the first 25% payment to local entities, to help defray impacts to local communities. I was just wondering, he didn't really know what the basis for that reason was by those state agencies, and I didn't know if perhaps you had any involvement in that.
I did not have any involvement, Ms. Chappelle, but just to clarify, I think what he said was we had offered to pay the 25% in advance, and they had asked that it just be paid in full, I believe, at abandonment.
Right. And I was just curious for the most part as to kind of how and why they came to that decision. Obviously not huge bearing, but just did want to understand that a little bit better, because I know the original intention of providing 25% upfront was to try to get folks kind of into some of those programs sooner rather than later. He also recommended I ask Mr. Sutledge that question. So who would potentially have that answer aside from the state agencies?
I am not aware of who right now who may have asked that question, but probably the best source, honestly, as you know, of that information would be the agencies.
Directly, yeah, absolutely. Going back to Ms. Nanasi's line of questioning, I did want to just have a couple clarifying questions. Is it true that the ETA section 7425 places a limitation on carbon dioxide exceeded from specific coal plants in New Mexico?
So I'll be honest, I don't have SB 489 in front of me. I was looking at the ETA codified as 62-18 -1 et sec. So I wasn't looking at the other parts of the bill.
Right. So just to take you back to that, the statement made was that the intention of the ETA was to essentially shut down coal. And so I just wanted to clarify section 36 of the ETA, which is codified at 74-2-5 B6, doesn't necessarily shut down coal in New Mexico, but would you agree that it creates a threshold of exceedance of about 1,100 pounds per megawatt hour after January 1st, 2023?
So subject to check, of course. Yes, there's a limit that was part of, I believe, the section you quoted in terms of emissions.
Correct. And then with respect to Four Corners, obviously there was a carve out there. Wouldn't you agree? And I think you made allusion to this, or you alluded to this, because it needs to be utility owned and run, but also obviously Four Corners is on the Indian reservation and not within the boundaries of the state of New Mexico for purposes of state law.
It's an interesting question. So I ETA doesn't discuss sort of the boundaries of sovereign lands, but it discusses basically, as we talked about with Ms. Nanasi, it specifically mentions a qualifying utility and whether it is owned or operated, which I think in the first case it's operated. In subsection 4 of section S, it talks about if not operated by the qualifying utility. So there's not a specific reference to tribal lands.
Correct. And obviously state law would apply to a state regulated and certificated utility. So that makes sense. The only other thing that I just wanted to clarify, Ms. Nanasi appropriately used the term abandonment. And I just wanted to get your concurrence. Isn't it your understanding abandonment is a legal term pursuant to the Public Utility Act? And what that refers to is abandonment by the public utility in question of their CCN for that particular resource.
I would agree that abandonment is a term that's part of the Public Utility Act and used within that. I think most people would, in common usage for San Juan Generating Station, we are talking about retirement. And in the case of Four Corners, we're talking about divesting or leaving our interests of that plant.
Correct. And so that's tied to the utilities ownership and operation of that resource.
In the case of San Juan, yes.
Yes. I have no further questions, Your Honor. Thank you. And so great to see you.
Good to see you too. Thank you.
And you were also right, by the way. Sorry, real quick. You were also right, Ms. Nanasi, that red is your color. I absolutely agree with that statement. So thank you.
Thank you, Mr. Powell.
Sir, thank you.
Mr. Albright, Bernalillo County has 10 minutes.
Yes, Mr. Hearing Examiner, and I have no questions for the witness, and just to go on the record that red is not my color.
Yes. All right, staff, Mr. Borman, 15 minutes.
Thank you, Mr. Hearing Examiner. I do have some questions. Good afternoon, Ms. Sanchez.
Good afternoon, Mr. Borman.
You are Chief Policy and Legal Advisor for Pnm Resources. Is that correct?
Yes, that's my title.
Okay. To whom do you provide policy and legal advice?
I'm sorry, you broke up. To whom do I provide?
To whom do you provide policy and legal advice?
I provide legal advice to the company, which is composed of any number of folks.
Well, maybe I can be more specific. First of all, who do you report to?
Currently, I report to Don Terry.
Don Terry. And so does Don Terry direct the issues that you are to look at?
Mr. Terry provides me with requests from time to time, as do a number of other members of the executive team, the EPC, but also other members of the company do as well. So I'm in an interesting kind of somewhat undefined, somewhat floater kind of position.
Okay. And what sort of policies do you advise or do you provide advice
I've worked on a variety of matters. Currently, one of my big projects, for example, is the grid modernization project, which is working on everything that's entailed in getting an application together to be filed later on this year for grid mod. Prior to that phase of it, I also worked on the legislation and advised the company and the government affairs folks on when the legislation was being considered. So that's one example. I also work on, there's a huge bipartisan infrastructure law that's happening currently that implementation is going through at the federal level and state level. So I am involved in staying on top of developments as to that law. So those are a couple of examples.
You mentioned you advised on legislation. What legislation were you advising on?
So most sessions I advise, well, actually every session since I've been inside PNM, but even prior to that, when I was outside counsel, I get asked to opine upon various aspects of legislation. So it's not necessarily any one bill, although in the context of this case, it was the Energy Transition Act. And prior to that, it was the precursor to the ETA, which was called the ERB, Energy Redevelopment Bond Act. So those are a couple of examples, but throughout my time with PNM, there's been any number of different bills that I've looked at and analyzed. So that's sort of in my wheelhouse to do legislative analysis.
Okay. So did you provide policy advice regarding the multiple decisions made by PNM to postpone the filing of the base rate proceeding?
I'm sorry, did you say of the base rate proceeding?
Yes.
I did not provide advice on that one, no.
Okay. Did you provide policy advice regarding the decision to postpone the issuance of the energy transition bonds?
I'm sorry, oh, issuance?
The issuance of the energy transition bonds.
I did not.
Did you provide policy advice about the decision to link the issuance of the energy transition bonds to the issuance of a base rate order?
So the linkage, I guess, if you want to call it that, was it was baked into, let's say baked. It was an assumption under which we were functioning as far back as the development of the concept of the legislation. So when you say provide advice, well,
who made that assumption?
I think there were several parties that were involved in the discussions, but certainly I remember myself having discussions with stakeholders, with legislators, with others about assumptions as we moved forward. Again, we're sort of looking at it, in hindsight, but at that point, there was an expectation that there were multiple rate cases that would be occurring. And so the sort of connection was there. I think you're asking me more specifically about this case, and is that correct?
I will be.
Okay, let me stop. Go ahead.
Well, all right. I mean, you said you had discussions, and this came up in discussions with, I guess, multiple stakeholders. Is that what you just said?
I believe so, yes.
Would that include stakeholders that represented customer interests?
I know that there were discussions had with the Attorney General's office. They represent consumer interests. We also had conversations with CCAE, who has consumer interests as part of their overall work. So, but I mean, as to the specifics, there were a lot of people in the room that were talking about this law.
So I'm asking about discussions about the linkage between the issuance of the energy transition bonds and the issuance of a base rate order. Was that the subject of discussions with the AG's office or CCAE or any other customer group?
So when we would talk about the ETA or the issuance.
Can I get a yes or no answer?
Actually, you can't, because it's more complicated than yes or no.
Well, I don't know. I think it is. But why don't you give me your answer and then we can assume it's a no.
Hearing examiner, I would ask that Mr. Borman allow Ms. Sanchez to answer her question.
She's refusing to. She won't give me a yes or no.
Mr. Hearing Examiner, it's the normal practice here in New Mexico that the witnesses are allowed to provide an explanation for their answer. They do not have to provide a simple yes or no answer.
Ask the question again, Mr. Borman, and we'll see if you can elicit the answer you're looking for.
Did you have discussions with CCAE and the Attorney General's office and any other customer group regarding the linkage between the filing of a base rate case and the issuance of the energy transition bonds?
I'm sorry, I'm struggling because my immediate answer is sort of, which is not what you're looking for. I understand. But
give me what you got.
Okay. So in explaining the concept of securitization, it was necessary to discuss how an asset like San Juan came out of rate base. As you can imagine, some of the participants were very sophisticated and knowledgeable about how that worked, others were not. So at times we needed to explain how an asset like San Juan came out of rate base, right? And in doing so, it was important to explain that a rate case was the appropriate mechanism for that. So with some parties, yes, that discussion came up and there was a mention of a rate case. With others, you didn't have to explain how rate making worked. As you can imagine, some are very, repeat players in these cases and understand the way the regulatory rate making process works, and that you have to look at the full cost of service, and that's how you eventually take out an asset like San Juan from rate base. So that's why I'm saying sort of, because you've asked me about a number of parties.
Okay. You just said something about how you take San Juan out of rate base. San Juan is rate base right now?
San Juan Generating Station, yes.
Okay, thank you. Now you in your testimony, you claim that, first you discuss at length the flexibility that you assert the ETA provides to PNM in the issuance of these energy transition bonds. Is that correct?
Yes.
Was that flexibility a goal of all of the participants in these discussions regarding the ETA?
I don't know what the goal was of other participants. I can't say that.
Was that particular flexibility discussed amongst the participants in the drafting of the ETA?
You're testing my memory here, Mr. Boardman, but let me think for a minute. I believe when we explained the way securitization worked in other contexts, meaning other jurisdictions, there was a general discussion about the need to have flexibility in a number of aspects related to the issuance of the bonds. So I think that was communicated at some point because that had always been part of the way we explain securitization. As you can imagine, now we, for better or worse, we know securitization enough. We've been through these cases. When we first were talking about this as a brand new mechanism for the PRC, it was very foreign in some cases. So we had to explain the way it worked in other states, the way that we were considering it for New Mexico. And so that flexibility was a part of the discussions at varying times.
So, and when you're talking about the flexibility, I've asked you about the flexibility for PNM to postpone the issuance of the bonds. Is that the flexibility that you were talking about?
Well, that's not what you asked me about, but.
Okay. Well, I asked you about the flexibility that you assert that it provides to PNM in the issuance of the energy transition bonds. Okay.
So maybe it would be helpful if you point me to the part of my testimony you're referring to.
Well, I'm trying to understand what you're testifying to. Did you have discussions with the parties that were working on this legislation regarding the flexibility for PNM to wait sometime after the abandonment of San Juan to issue the bonds?
I believe what I've already testified to, Mr. Borman, is that we anticipated at that point that there would be at least 2 opportunities in rate cases to address the removing San Juan Generating Station from the cost of service overall, right, in a rate case. So did we at that point, was there a need to have a discussion about the potential to move that? I think we were in a different world back then. It was pre-COVID.
So your answer is no.
I don't remember having a conversation about linking those 2 things. I don't think that the issue it wasn't even part of anybody's anticipation that there wouldn't be a rate case in the last 4 years now since we.
So there was no customer group like CCAE or the AG's office that indicated that they were comfortable with giving PNM the flexibility to time the issuance of the bonds at a different time than the abandonment of the Four Corners, the San Juan unit.
This issue is not on anybody's radar, Mr. Borman.
Okay, thank you. Those are all my questions.
I didn't mean to cut you off, Mr. Borman.
No, that was it. That was it. So last thing on my list.
Okay, I don't like to interrupt, but
not at all.
All right, thank you, sir.
Thank you, Ms. Sanchez.
Thank you, Mr. Borman.
Hearing examiner Schanauer.
Yes, thank you. I have a few questions. Good afternoon, Ms. Sanchez.
Good afternoon.
My questions all relate to the discussion you had with Ms. Chappelle about the Air Quality Control Act 74-2-5.
Okay.
Remember that?
I do, and I'm sorry. Let me see if we have that section because I didn't when Ms. Chappelle mentioned it.
Ms. Sanchez, I'm just curious. Has someone been in the room with you the whole time?
I'm sorry. We have a regulatory person here who hands me documents. So yes.
Okay.
And it's not, I don't know if you need me to have her come show her face, but she's.
No, it's okay. Just curious.
Yeah, so we have a room in here and we have all the exhibits and somebody hands them to us just to make sure we're not off camera while we're shuffling papers.
That sounds efficient. I just was wondering.
Yes.
Thank you.
And I just, for the record, I don't think that I have a copy of SB 489 in front of me, and it may take a little bit for me to pull up the section that Chief Hearing Examiner Schanauer is referring to, but.
Well, let me just ask you
Sure.
Your understanding of what that section does. I mean, as I think I heard your discussion with Ms. Chappelle, the discussion suggested that the legislature established the new emissions limit for carbon dioxide from coal plants. Is that what you intended to say, or?
Thank you, I'm sorry, Hearing Examiner Schanauer, but no, it established an air emissions limit. So it wasn't from coal specifically. It created an air emissions limit. So the ETA part, so what we've been discussing, that's part of section or chapter 62, was specific to the retirement or transition out of coal. But then that section discusses a limit on emissions generation in general. So I think the presumption was that it would be a different fuel. There'd be an emissions cap on another fuel source of any other kind of generation.
Well, could I read to you what the statute actually says, and
Please go
we
ahead.
can talk about it? This starts with subsection B, and
D, I'm sorry, D or B?
B like boy. It says the Environmental Improvement Board or the local board shall, and then you drop down to subsection 1 under that, which is adopt, promulgate, publish, amend, and repeal rules and standards consistent with the Air Quality Control Act to attain and maintain national ambient air quality standards and prevent or abate air pollution, including then you drop down to another subsection, which says B, lowercase b, standards of performance that limit carbon dioxide emissions to no more than 1,100 pounds per megawatt hour on and after January 1, 2023 for a new or existing source that is an electric generating facility with an original installed capacity exceeding 300 megawatts and that uses coal as a fuel source. Did you get that?
I did, Mr. Hearing Examiner, and I've also, we've now pulled it up, so I was reading along with you.
Okay. My question is pretty simple. At subsection B says the Environmental Improvement Board shall do those things. It doesn't say that those standards have been established by the legislature, right?
So I think the limit, the threshold has been established, but how that actually occurs is delegated to the EIB. Yes.
Okay. Well, I guess my question is, has the Environmental Improvement Board done that yet?
I am not sure, to be honest with you. I don't believe so because I have not heard that they have completed that. But as to what their status is on working on that, I don't know.
Okay. Right. That's all I wanted to know. Thank you.
Thank you.
Thank you. Ms. Twilliger, you have any redirect?
No, Hearing Examiner, thank you.
Okay. Any follow-up? All right. Ms. Sanchez, great to see you again. Thank you so much for your testimony. You're excused.
Well, thank you, Hearing Examiner Medeiros. I thought you were going to ask me questions. I'm bummed out, but okay.
Oh, I'm sorry.
No, you're fine.
Now that you mention it, no, I'm kidding. Thank you so much.
Thank you. It was a pleasure. Appreciate it.
Likewise, always a pleasure.
Thank you.
Okay, we have concluded the presentation of evidence for today, and we will start up tomorrow morning at 9 a.m. with Noah Long. And then we'll have Mr. Dauphiné and Mr. Meyer testifying tomorrow. And then Friday, we have Mr. Fetter, Dr. Blank, I think it's Dr. Blank, right? Larry Blank, John Reynolds for staff, and then Mr. Setledge hopefully will be recovered enough to be able to testify. But I'm not sure about the order of testifying on Thursday. Ms. Twilliger, did you have something?
Yes, Hearing Examiner, I just kind of wanted to alert the parties that it's probable at this juncture that Ms. Stella Chan is going to have to adopt the testimony of Mr. Setledge. So I know Ms. Gould in particular had transferred 30 minutes. I mean, Ms. Chan is doing everything she can to get up to speed on Mr. Setledge's testimony, but she was not the original witness in this case, and I just wanted to let the parties know that probability is increasing, that it will be Ms.
Well, sorry to hear that for Mr. Setledge's sake.
Yeah.
And I thank Ms. Chan for stepping into the breach. If Ms. Chan testifies, would you? I'd like to have Mr. Reynolds go last, preferably. Could Ms. Chan testify first on Thursday? if that's required.
I have not asked her that question. I'm sure she'll do her best to make herself available. So let us double check, and I'll check in with you in the morning.
Looks like it'd
Okay,
only be
it's-
about 40 minutes. Difference.
That's fair, Mr. Borman. We will. I'm sure Ms. Chan will make herself available.
I just want to establish an order of witnesses for Thursday. And right now, we're not going to do that, but we'll know tomorrow. And just bear in mind, we'll talk about it, but I just want to establish an order of witnesses. And typically we go with Pnm's witness first and staff's witness last. That's my only intention there. Ms. Gould.
Sorry to interrupt you. Tomorrow, it seems, if my math is correct, which it's late in the day, so I could be very wrong, that there is only an hour and a half. Am I missing something? 30 minutes Noah Long, 30 minutes Mr. Dauphiné, 30 minutes Greg Meyer.
No, that's correct.
So
But Mr. Fetter cannot testify tomorrow, I believe. Fetter is unavailable Wednesday.
Yeah, excuse me, I don't mean to interrupt, Mr. Hearing Examiner. I could call him, get on mute and call him right away and see if he's available for tomorrow, if you'd like me to do that.
Sure.
Okay. I'll do that right now.
Okay. And that because and we have 40 minutes for we have a substantial, a bit more time with the P&M witness. So if we could fill some time tomorrow, that would be great.
it looks like Larry Blank also only has 30 minutes. And I know you want Mr. Reynolds to go last. And he has 42.
If we can move witnesses up to testify tomorrow, I'm certainly open to that and hopeful that that could happen.
Hearing Examiner Medeiros, I did
Yes.
reach him. This is Marilyn Nessie, and he would be available at 1 o'clock tomorrow if that serves your purposes.
That might still require a bit of a break between Meyer and Fetter, but yes, I would move Mr. Fetter to after the lunch break tomorrow and have him testify tomorrow. In fact, I'm doing that now if he's available.
I just asked him and he said he could be at 1 o'clock.
Okay, so then the reason I said it that way is I just want to confirm that Mr. Fetter will be testifying tomorrow afternoon. Is he available the rest of the afternoon if we go a little bit longer?
Yes, sir.
Okay, so Mr. Fetter, thank you, Mr. Fetter. You're out there for agreeing to testify tomorrow afternoon. So we could probably have, I don't know if Mr. Blank's or Dr. Blank's available. We could add Mr. Blank or Dr. Blank to testify after Mr. Fetter tomorrow. We could conceivably finish the hearing tomorrow if the rest of the witnesses are available tomorrow.
I'm sorry. I would have to confirm with Mr. Blank that he's available at all tomorrow. I know that he has other cases going on and he has some things to schedule around. But I can reach him tonight.
All right, now you recall, Ms. Beatles, recall from the pre-hearing order that we have a commitment. Mr. Blank was not available on Monday. This is not an accusation or any kind of criticism at all. It's just that a reminder that we ask that witnesses be available on a rolling basis for the next day, if possible. And he did block out Monday all day for unavailability. So I'm not, it would be nice to know if he could be available to test,
I
because we
will-
could finish the testimony tomorrow, potentially.
What window of time tomorrow should I ask him specifically about? The afternoon, late afternoon?
Afternoon,
Okay,
say, yeah,
starting at,
I think that Mr. Feder, that there's only 35 minutes of. So, you know, I don't want to be.
two-ish. Two-ish for
Of course.
blank.
Yeah, of course, the hearing examiners may have questions as well, but
And then could P&M check to see if Ms. Chan could also testify tomorrow, because how long do we have? I have still 185 minutes for settlage. Is that consistent with what you have, Mr. Williger?
I'm certainly not the official record keeper, but that is consistent with what I have, yes.
Okay. So we're not going to, probably not going to be able to finish tomorrow anyway, but let's find out if we can have, still have blank testify tomorrow, and then we would have on Thursday, likely Ms. Chan, unless Mr. Settlage makes, is recovered well enough to testify. And then we'll still conclude on Thursday with John Reynolds. But for now, the order for tomorrow is Noah Long, James Dauphiné, Greg Meyer, and Stephen Feder. Mr. Elliott?
Mr. Hearing Examiner, I have a conflict tomorrow. I have another hearing. I request to be excused. I haven't reserved any time for these witnesses.
No, you're excused.
Thank you.
The Attorney General's excused. Is there anything else before we conclude tonight's hearing?
I would just request, Mr. Hearing Examiner, this is Kelly Gould, if PNM could ask Stella, just in case, Ms. Chan, just in case for some reason the testimony goes faster than anticipated tomorrow, whether or not she's available.
PNM, could you do that to see if Ms. Chan would be available tomorrow afternoon?
She can be available, although I would say just because she's still trying to get up to speed. If we're going to extend into Thursday, I think it would be better to have her testify Thursday.
Because again, we still have, by my spreadsheet at least, we still have 3 hours of cross-examination reserved for settlage. So that would still carry us over unless things do move faster tomorrow, and that's possible that they could. But for tonight, let's go ahead and recess with, again, Long, Dauphiné, Meyer, and Feder, but we will start tomorrow morning, 9 a.m. with Noah Long. If there's nothing else, I will recess the hearing for the evening and we will see everyone tomorrow morning at 9 a.m. Hearing nothing, thank you all. Have a good evening.
Yeah.
Thank you. Good evening.